So that's not an issue, it's just making sure everyone else is.
Well, and primarily if the defendant is available, but as Mr. Maddox stated, we do have a proposal for a bond that would require pretrial conditions and other safeguards that we normally seek. If the court is open to that, we can proceed with that as well.
I mean, I don't know if they would do it as absence, but I'm fine putting it for tomorrow.
Yes, sure. That would be appropriate.
Just to make sure that it's done. Unless everything needs to do it, but then it still has to be ordered to do it. Make sure he receives the order.
Of course.
It's a very serious allegation that denies it according to the report, but we have to do things the right way and find out what's going on.
I concur.
All right, let's put it on for 9 o'clock tomorrow. This is, see if you can get them back here. Take it from there.
Sounds good. Thank you.
All right.
I'll call the jail this afternoon and see if I can find out more. If he's back in the jail, I'll sure go see him.
Thank you, Your Honor.
What about a meeting? Are we gonna handle that?
Sorry, Your Honor?
I'm talking to Mr. Klein.
Okay.
Your Honor, Miss Amin is present. She's approaching. I've been talking with Mr. Sprouse. See if there was a way we could avoid the hearing. Mr. Sprouse has indicated he wants to move forward with it. So I guess we'll start the hearing.
You ready to go forward?
State's ready.
Yes, Your Honor.
Take your seats and go from there.
May it please the court.
Yes, go ahead.
We're
Announce
here.
the case. This is, go ahead.
Yeah. So we would like to call Deputy Michael Raish.
All right, let me stop. I thought you were announcing the case.
Okay, I thought you.
2025 CF 2087, State of Florida versus Amasia Amin. It's the pretrial detention hearing. She's
Information was filed, Judge.
information was filed on December 8th of 2025. Trafficking fentanyl 14 grams or more and resisting without.
Yes.
Your first witness again
Is Deputy Michael Raish.
All right, thank you. Can you raise your right hand? Do you swear or affirm the testimony about to give us the truth, the whole truth, and nothing but the truth?
I do, yes, sir.
All right, take a seat there. Make sure you speak into that microphone.
May I move to the podium?
Yes, please.
Good afternoon, Deputy. How are you?
Good, sir.
Can you state your full name for the record?
Michael Joseph Raish,
And where do you work at?
Okaloosa County Sheriff's Office.
How long have you worked there?
This month will be 3 years.
Okay. Where is your assignment?
I'm a North District Patrol Officer.
Okay. Are you familiar with the defendant, Amasia Amin?
I am, yes, sir.
How so?
She was, I initially became aware of her as a victim of a battery case that a coworker of mine was working. In the process of working that case, she was identified as a potential involved party, likely the victim. She had left the scene before we were able to interview her, and when I later located her to interview her in reference to that call, I found her driving through town and conducted a traffic stop to interview her.
Okay. Is that the only reason for the stop?
Yes, sir. It was reasonable suspicion that a battery had occurred, and we were not 100% sure who was the suspect. Hadn't been able to interview both parties, and yes, sir.
Okay. So she was detained and not free to go, and you pulled her over?
So I stopped her, and then I turned my lights off, conducted as consensual of an encounter as I possibly could, asked her if she didn't mind speaking with me and so forth, and she advised that she had no problem talking with me, and we started discussing the case, and yes, sir.
The battery case?
Yes, sir.
Excuse me. While you were on scene with her, did anyone else approach the
Yes, sir.
situation? Who?
Yes, sir. So it would later be identified that the owner of the vehicle that she was driving arrived. I guess her and her boyfriend, the suspect in the battery case, had borrowed this vehicle, and they had yet to return the vehicle. He was looking for that vehicle, as again they were late in returning the vehicle to him, and he happened to see us on the side of the road
With his vehicle?
with his vehicle. Yes, sir.
And what did he ask you to do anything?
Yes, sir. So if I'm not mistaken, he asked Lieutenant Kelly, who arrived on scene as well, if we could search the vehicle prior to releasing it to him. He was taking possession of the vehicle. Ms. Amin stated that she had no problem with that, and I asked her to step out of the vehicle, grab any belongings that she had, and we conducted a search of the vehicle.
Okay. At what point was Miss Amin not free to go? Excuse me.
At that point, she was released from the vehicle. I asked her, hey, he's taking possession of the vehicle. I said, hey, grab whatever belongings and everything that you need out of the vehicle. I asked her if she had any belongings left. She stated she didn't. She grabbed her purse and I believe a dog and left and started sitting on the street corner trying to find a ride. And during the search of the vehicle that the owner consented to, we located a scale with white powdery substance, which I identified through training experience as likely being narcotics. And at that point, I asked her to come over to the vehicle, told her to settle her stuff down, and she refused.
So it was all consensual until y'all found the scale?
Correct.
Okay. Once you found the scale and you told her that she was not free to leave, what happened next?
So I asked her to step over to the vehicle, asked her to set all of her stuff down on the hood. She spontaneously stated that she was not going to be searched. I said, yes, ma'am, you are. And she started backing away. I grabbed her arm and she began resisting. She had to be escorted to the ground and placed in handcuffs before being detained in my vehicle.
Okay. Did you end up searching her?
Yes, sir. I briefly searched. She wasn't wearing clothing with a lot of pockets. I searched her pockets and made sure that she didn't have any weapons or any officer safety issues. She was placed in the vehicle, and then the belongings that she was carrying were searched, and in that purse there was a large quantity of a supposed substance or illegal substance that during roadside testing appeared to be positive for cocaine.
Okay. Have you been apprised of what the FDLE said
Yes, sir. Afterwards, that substance was seized. She was arrested and charged for possession of cocaine. And then after the fact, that substance was sent to FDLE for testing. They responded back and stated that it tested positive for fentanyl.
Okay. Did you seize the defendant's phone?
I believe yes, sir.
Okay. Do you know if there was a search warrant for that phone?
I did not request one. That would have been handled by our special investigators on the back end of it, and I'm not privy to that information, sir.
Mm-hmm. How much fentanyl was it?
If I'm not mistaken, I believe it was 21 grams.
Is there anyone else charged with those substances?
At this point, no, sir. Again, I don't know what the special investigators would have done with that case after I made the arrest on Miss Amin. But at that point, because she was sitting where the scale was found, and when I searched her purse had the narcotics. She was the one that was charged.
That's all I have, Judge.
Ross, Mr. Clemens?
Investigator, were you present in Laurel Hill when this disturbance happened?
I was not present, no, sir. We got called by a third party who stated that they overheard a physical disturbance. One of my coworkers responded, and upon arriving on scene, Miss Amin's boyfriend at the time fled on foot, and we all responded to assist.
So you were at the scene up in Laurel Hill?
I was at the scene, yes, sir.
Okay. Did you talk with Miss Amin when you were up at Laurel Hill?
At that point, I don't know that anyone was really able to conduct an interview with Miss Amin, as whenever the foot pursuit began, she left the scene. Which is why I was trying to locate her later at that point.
Who was the arresting officer on that misdemeanor case?
On the battery,
Yeah.
that would have been Deputy Asia Sprague.
Okay. Can I, Your Honor, may I approach a witness?
Yes, sir.
No. This is not your report. Just so the record's clear, this is not your report, okay? So I'm not holding you to what's the contents here.
Mr. Clemens, I don't know if whispering to the witness is something we're allowed.
Oh, that's fine. I was trying to draw his attention.
Okay, we'll just
You're talking about where?
do that on the record.
You talking about the injured?
I'm sorry. Talking about speaking.
I don't believe, no. I don't know if that's.
I don't know what the question he's answering is.
So, Deputy Sprague wrote this report, right?
Yes, sir. She would have registered the initial report and the arrest report on the battery that occurred up in Louisville.
And part of this report, which you did not write, just to be candid, says while Deputy Sheriff Rich.
I believe this is improper impeachment.
Mr. Clemens.
I'm not impeaching him. I was refreshing his recollection. It's a document that he didn't write. But the document specifically says he was speaking with Miss Amin in Laurel Hill,
Who was?
Deputy Rich.
Oh,
So do you recall speaking with Miss Amin up in Laurel Hill about this battery?
No, sir. I know that, if I'm not mistaken, while Deputy Sprague was up in Laurel Hill and investigating that scene and handling that, attempting to interview him before he was transported either to the jail or to the hospital, I had located her and the traffic stop ensued.
And that traffic stop was because you believe she may have been what?
At that point, we did not know which, we hadn't had a chance to positively identify her. We just knew that she was involved in a physical disturbance, in which case injuries were delivered to the suspect. But we did not know her role in entirety.
So is this report from Deputy Sprague, is this incorrect?
I don't know, sir.
Okay. So the traffic stop was initiated because you needed to talk to Miss Amin.
Correct.
Right.
Yes, sir.
Now, you had testified just a minute ago that her items were searched after she was placed in the back of a police car. Was she in handcuffs in the back of that police car?
Yes, sir.
Okay, and she was in the back of a locked police car, correct?
Yes, sir.
Would you agree that it would have been next to impossible for her to get out of that car and out of those handcuffs?
Yes, sir.
And you searched, and you did you have a warrant at that time?
No, sir.
Okay. Why didn't you go get a warrant?
We were searching incident to arrest, and we had already located narcotics. She was detained, and her items were searched. The items that were in her immediate possession at the time.
Did you ever talk to Mr. Arrington up in Laurel Hill?
Other than determining his welfare, asking if he needed a bottle of water, not to my memory.
Okay. Do you know when these drugs were put in this purse?
If I'm not mistaken, I asked Miss Amin about that, or attempted to, and it should be in my supplemental report. She stated that she did not have any memory of anybody putting the narcotics in her purse, and she was in possession of her purse all day that day.
Right. Did she also tell you that she'd also just woken up at one point and she hadn't looked in her purse that day?
I don't remember, sir.
Okay. But the answer to the question is, then would be no. You don't know when the drugs were put in the purse, right?
No, sir, I do not.
Okay. Do you know who put them in the purse?
No, sir.
Did Miss Amin ever make any categorical statements that these are my drugs?
No, sir.
In fact, she consistently denied it, didn't she?
Correct.
Did you ever get any fingerprints off that scale?
No, sir.
I don't think I have any other questions.
Was the scale in plain view?
Yes, sir. Whenever I asked her to step out of the vehicle and advised her that the registered owner of the vehicle had requested a search of the vehicle, I observed something, I observed it in the floorboard whenever she stepped out, began searching and picked it up and realized that what it actually was, I believe it was flipped over, so it wasn't immediately apparent what it was.
It was on the driver's side floorboard?
At that point, she had moved she began the stop in the driver's seat and she had moved to the passenger seat. And whenever I
Can you
asked her to step
explain
out of
that?
the vehicle,
To the court, how did she move from the driver's seat? Did
I
she
don't,
step out of the car?
I don't remember, to be completely honest with you, sir. I know that I began talking with her in the driver's seat, and I don't remember why, but she ended up moving into the passenger seat.
I have no further questions.
You can step down. Step.
The state has no other witnesses, Judge.
Witnesses from the defense?
I have an exhibit, Your Honor. If I may approach, I've talked to Mr. Sprouse, he does not object to the introduction.
That's correct,
No
Judge.
foundational objection or anything? We don't need a witness.
No, Judge. I mean, I'll argue about it, but
Okay, so this looks like text messages, this is defense exhibit A, you're not objecting to it being entered into evidence?
no, I have no legal objection, Judge.
It'll be admitted. Yeah. Court's review exhibit.
We don't have any other evidence. That doesn't matter.
Argument for pretrial detention, Mr. Sprouse?
Yes, Judge. The three things that the state has to prove for pretrial detention in this situation is that the defendant is currently charged with a dangerous crime, that is trafficking fentanyl. It is the only trafficking charge that is inherently dangerous under the statute. The second thing is that there's a substantial probability that the defendant committed this crime. I believe, given that she was the sole occupant of the vehicle when she was pulled over, that the 21 grams of fentanyl that was located in her purse, that there was a scale at her feet that is...
When she was driving or when she was sitting in the passenger seat, 'cause I'm not clear.
The scale was on the floorboard of the driver's seat, whether she was driving, whether she was a passenger. There was no testimony of the scale just like ending up there after, furtive movements. The officer testified that he saw her with the scale at her feet and was only aware that it was the scale once he was able to flip it over and confirm it.
But she would have known,
She would have known.
even though someone else who saw it didn't know what it was.
Because the officer only has a few seconds to assess the situation. That's the car that she's been borrowing. We don't know how long she's borrowed that car, but we know she borrowed it longer than she was supposed to. So then you couple all of that with the fact that she said, "You're not searching me," and she chose to pick up a new charge to try to avoid being held accountable for the drugs that were in her purse. That text message that you see that the defense introduced, we don't know who it's from. We don't know who it's to. Presumably it's with the defendant and the person that, I guess, battered her that evening. But she's not mad at the defendant. She doesn't say, "Can you believe that the cops found all those drugs that are yours?" That's not what was said. So I believe that there is a substantial probability, given the facts, that she has committed the crime of trafficking fentanyl. The third prong is that there is no condition of bond that would protect the community from a dangerous person. Well, Judge, I don't believe that there's a condition of bond that you can put to stop the defendant from trafficking fentanyl. People can show up to her house and she can serve from wherever she's at. The GPS monitor is not going to stop that from happening. Fentanyl is physically dangerous to this community. So, given that, Judge, we would ask you to grant our motion for pretrial detention.
Mr. Clemens?
You're going to go into the substantial probability aspect of things. I would submit, based on the contents of that text message, that the probability is in question of who possessed these drugs. I will concede. I mean, Mr. Sprouse makes some fair points. Like, what I presented as evidence is a text message exchange. The court doesn't have any evidence who it's from, or who it was to, who sent it. However, yesterday I asked Mr. Sprouse if he could try to track down the body cameras in 25mm2970. That's the battery count from up in Laurel Hill against Mr. Arrington, where if he's on body camera saying that, then I don't know if he is. But I mean, that's why I need body cameras from a misdemeanor case, because the question becomes, if he actually is on camera telling a deputy, I put something in her purse, I mean, that, I would almost say fatally weakens the state's case against her. So, and all this is yet to be proven. I mean, I'll be the first one I'm usually the first one in here saying this is so early in the process. It's a little bit unusual with Miss Arrington because we actually have the discovery in Miss Arrington's case because she got arrested in October. So she's been out on bond since October. So I would submit that the substantial probability question is it's not apparent. It might turn out to be her. I don't know. But at least right now, that's in question. Number 2, Your Honor, on the state's motion, court must find a substantial probability that the defendant committed the dangerous crime charge and, based on the defendant's pattern of behavior and other relevant facts, no conditions of release, will reasonably protect the community from risk of physical harm, ensure the defendant's appearance, or protect the integrity of the judicial process. Her pattern of behavior is she comes to court. That's her pattern of behavior. Ms. Amin was present on December 4th when her case was on the arraignment docket, and I know she was present, and if the court wants to put me under oath, I'll repeat the statement, but I talked to her. I remember her being there. Like, I talked to her. I didn't even know who she was. She was present. She was present last Monday when she knew that this hearing was going to possibly occur. She was present before the court last Monday. She is present before the court now. Like, her pattern of behavior is, I don't know what else she can do to ensure her appearance other than show up every time, which she's done. I've talked to her on the phone 4 times. She is not a hard person to get in touch with. She was, I watched the body cameras that I do have yesterday. She was not the most compliant person on the scene. I mean, she was upset. She'd just been battered by her husband, by her boyfriend. Now she's getting pulled over, probably not knowing why am I being pulled over. And I don't even know if that's a legal reason to pull somebody over. There were issues in the case. I mean, obviously we're getting ahead of ourselves. I asked the deputy specific questions because that sure sounds like it fits with Gant. Like, if she's in the back of a police car in handcuffs, then they cannot search bags, incident to arrest. Gant specifically talks about that. That's one of the 2.
The facts of Gant are very different. I understand. I mean, it's the first thing that pops in my head when I hear things like that, but I'll address those when I get my...
For sure. I mean, I'm pointing out that that's a potential issue. The reason for the stop is a potential issue. She's been in court. She's been out on bond for about 5 months, give or take, since October. She has no prior record. The state, unfortunately, in Florida, the state can charge somebody with trafficking just for possessing. And other than the scale, which we don't know what that powder was on the scale. As far as I know, it hasn't been tested. So I don't know if that powder is fentanyl, if it's cocaine, if it's meth, if it's baking powder. I have no idea. But this idea that Miss Amin is just slinging dope all over the place doesn't seem to be supported by what the court knows right now. And so we would submit that her pattern of behavior, she hasn't picked up any new charges since she's been arrested. I'm sure Mr. Sprouse will be telling you if she had. She has no prior record. She comes to court. She's protecting the integrity of the process. I don't know what else we can do to show that pretrial detention would be inappropriate in this situation. I mean, certainly she's looking at a 20-year minimum mandatory sentence. That is the weight of the drug, you know, but there's a real question of who may have put the drugs in the purse, you know, and there are kind of related questions of where the searches even lead. So I don't know what else she can do other than come to court repeatedly, which she's been doing. And as I said, I'll end it on this. I mean, we're early in the process. I don't know how any of this is going to play out, but I mean, she's done everything she can do to protect the process, to make sure that the court doesn't have any concerns about her. She lives in Pensacola. She doesn't even live in Okaloosa County. She drove over here. You know, she's driven over here 3 times. She works at Amazon. She works 50 hours some a week. I don't know what else she can do. So we would argue that there's not a substantial probability that she committed this crime, and that she has done everything she can to protect the integrity, ensure her appearance, and because she's picked up no new charges, the community does not appear to be at risk of physical harm.
Mr. Spence, anyone else?
Yeah, briefly. The defendant fled the scene where she was.
Seeing where she was all, when you determined to be the victim?
Exactly. So that goes to show that she knows that there's fentanyl in her purse. That's why she fled. We believe that we've met the burden. The third prong is a difficult one, but however, the danger to the community of selling fentanyl or trafficking fentanyl is one of the biggest blights on our community right now.
I think you keep saying that, Mr. Strauss, because you know the evidence that you have here is weak. And let me explain it. From what I heard, I don't know what y'all saw on body cams, what you've all read in other reports regarding related but somewhat unrelated cases. What I heard is there was a call from what I would guess is a unknown caller, I don't know who that person is, who said there was some sort of disturbance. When officers get there, the person who's ultimately arrested for that disturbance runs. From what I gathered, again, there's a lot of missing pieces here. Everyone went after the perpetrator of the disturbance. No one stayed with Miss Meade. She then gets in her vehicle and leaves. No one ever told, I never heard anyone saying she was not free to go, that she had to stay there. And so she's ultimately pulled over, again, based on, from what I've heard, the facts may be different, but I can only judge it based on what I've heard. An unknown informant saying there was a disturbance that was not corroborated. And then they pulled her over as the victim of this crime. There's no allegation that she's committed, was committing, or was about to commit a crime. So you've got potentially a bad traffic stop. Ultimately, she's asked to exit the vehicle. A scale is seen that was in plain view, except no one talked about it being in plain view until she got out of the car. The officer testified that it was upside down, and he didn't know what it was until after he picked it up and manipulated it in some way to see what it was. But yet she should have exact knowledge of what it is. It all assumes that she's already guilty of possessing this paraphernalia. I'll point out to the state that when you filed your information, you didn't file on the paraphernalia, did you?
No, Judge.
Okay. It had a white substance on it, which, as Mr. Klein's talked about, not sure what it is. She was ultimately then searched because of something that was in the car that's no longer hers. And again, I don't know if it was on the passenger seat or the driver's seat, and when did they first see it. It's somewhat of a mystery still based on the evidence that I've heard so far. She's then searched. They find what they think, based on the field test, is cocaine. She says at the time she doesn't know what it is, and it's not hers. Turns out it's not cocaine, which is what she was arrested for, because the lab comes back to say it's not what even the police thought it was. But yet she supposedly knows exactly what it is, even though the testing that was done on the roadside said it was something different. trust me, I agree with the state when it comes down to fentanyl being a huge issue, not only in this county, this state, this country, but I don't think this is a case that's worthy of pretrial detention. I think there's potential, possibly several suppression issues that have to be dealt with. And then the reason I'm bringing this up is both the rule of criminal procedure 3.132 and the relevant statute 907-041 both talks about whether or not evidence is admissible if it was obtained in violation of the Constitution of the United States and the state of Florida. Certainly concerns on that based on, again, what I've heard. I haven't watched any videos. I haven't been involved in any sort of depositions. I can only go forward with what was presented. So I don't think there's a substantial probability that she committed the offense based on what I've heard. I haven't heard any evidence about any pattern of behavior. All I've heard is she has no criminal record. She's been here to court when she's been asked to be here. She hasn't committed any new offenses since this happened. So I'm not sure what the pattern of behavior even is, let alone is it sufficient. And this is kind of contrary to how these pretrial detentions usually go. Usually the person never gets out of jail while they're waiting for the pretrial detention. She was released because at first appearance she was only charged with possession of a controlled substance that I think was cocaine, which it turns out that that's not what the substance even was. And then the state filed this motion for pretrial detention based solely on what FDLE found. And so she's been free and not committing any crimes and showing up to court for 5 months in the meantime. So the only pattern she's shown is of lawful behavior of showing up for court. I don't see any issues with her compromising the integrity of the judicial process. Frankly, I'm not quite sure where this case is going to go, but there's seemingly quite a bit of problems with it. So I'm going to deny the motion for pretrial detention for bond will remain as is.
Thank you, Judge.
If we can just leave this on the April 27th docket. I mean, clearly there's going to be depositions that need to be taken, but we'll leave it on and file a motion to continue.
Okay. April 27th at 9.
May I approach, Judge?
Yes.
Damn thing ain't working. Whoa! Not cool, bro.
I'm Attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We haven't heard anything from Mr. Williams' office as far as Mr. Noakes, but my assistant saying that he served them with the notice, or at least the order appointing, but I'm not sure if there was a notice of the hearing that had ever been done. So we're just trying to figure that out before we decide what we're going to do with Mr. Arnett and Mr. Penny.
I'm going to step out, Judge,
Okay.
and try to call Mr. Williams.
Your Honor, I don't know if I'm allowed to, I'm Carson Arnett.
No, ma'am. And we did this last time, but I need to have the parties present and the attorneys present before I can really go any farther.
All right. And I did try to reach
Ma'am.
Mr. Williams, but I know phone calls.
Still talking.
I'm just, this is, people have to be here for this to be on the record, and kind of shouting from the gallery is not the way it's supposed to work. In fact, I'm gonna take about a 15-minute recess to see if we can track down Mr. Nopes and Mr. Williams, because we don't have a docket until 1:30 anyway, and see if we can figure it out. But my understanding is the orders were sent to their email addresses on the day that they were signed, how they normally are. So that's why we're trying to track down why they're not here.
I'll let you know if we learn something on this second.
All right, we'll be in recess.
All rise, please.
Make sure everyone turn their phones off, please. All right, so we were able to contact Mr. Nope's office. He represents Mr. Cunningham. He said he can be available tomorrow. Does that work potentially for the state and or your witnesses?
He works tomorrow.
I think the issue is that they got notice that they had these cases, but I'm not sure they received anything that said it was today.
Correct.
We're still trying to reach out to Mr. Williams' office. My office has sent out emails and left voicemails, and we haven't heard anything yet.
I believe Mr. Williams is on the docket.
He's on the 2 o'clock time?
Tyson Morris.
Okay, we'll address it then.
There's a hearing, is a hearing at 2 o'clock.
Okay. So
This
it'll be a little delayed, but
We're available tomorrow for for at least that hearing.
okay. Let's just hold them here for now until we know for sure what's going to happen. Because I don't want Mr. Williams to show up and say, like, I don't know anything about this yet. And if he's not prepared, let's just all set it all everything up for tomorrow. I know that's not easy, but I'm trying to make lemonade here, folks. It's just not easy, but when we have these multiple co-defendant cases, sometimes this is just the best we can do to get appointed lawyers appointed.
As far as the hearing that might happen today, my officer is on duty. So,
Well, Mr. Williams should be here shortly.
okay.
And I'd like to get these things done, but unfortunately, this is the problem. We're trying to avoid having numerous hearings related to the whole same facts, same witnesses. But there's so much I can do to get everybody here. I send out invitations, it's up to people to show up. So why don't we start going through? It's not even, oh, it is after 1:30. Clock was right. All right, we're going to start the 1:30 docket. I apologize for all that, everyone who's here for the 1:30 docket. I'm Judge Oberliesen. This is an arraignment docket. What I'm going to do is I'm going to go down the arraignment docket alphabetically. I'm going to call you up by your name. I'm going to tell you your case number, what you're charged with. I'm going to verify if the state has filed an information or charging document against you. And also, if you're represented, I'll talk to your lawyer about some further issues. Otherwise, if you're not represented, I'll talk to you about that as far as, are you going to hire a lawyer or would you like to have one appointed? And then I'll answer any questions you may have. Although this is not a trial, we're not going to talk about the facts of your case. All right, Avery Amos. All right, Mr. Amos.
Yes, sir.
Okay. You're here in 26 CF 256. You've been handed an information or charging document that shows that you've been charged with dealing in stolen property, which is a second-degree felony and therefore punishable by up to 15 years in prison. Do you understand that, Mr. Amos?
Yes, sir.
All right. You don't have an attorney here. Do you plan to hire one, or would you like me to appoint you one?
Point one, sir.
Okay. Are the applications on the lectern there?
Yes.
So this is Mr. Maddox from the Public Defender's Office. He'll be handling your case, although I do need you to fill out one of those applications today. Drop it off downstairs to the clerk's office on the first floor on your way out. Otherwise, I can't appoint you a lawyer. So make sure you do that.
Yes, sir.
Mr. Maddox, an information's been filed for dealing in stolen property.
Yes, Your Honor, I went to plead not guilty this time of demand trial by jury. If I may, Your Honor, just to prevent further issues from coming up, in some of the minute sheets that come to our office, the name is just marked out and they'll fill in my name. It's very clear and the court's intention is very clear, but our office cannot open a file unless the box that the public defender has been appointed is checked. I just want to make sure that's done.
Okay, thank you. All right, as far as any case that's on this docket, do you want to set it for the April pretrial?
Yes, Your Honor, the April
Okay.
pretrial conference.
All right, so Mr. Amos, you're going to come back on April 27th at 1 p.m. Stay in touch with Mr. Maddox, and we'll see you back on that date.
Yes, sir.
All right, thank you.
So we'll discovery, but, you know,
Charlene Francis.
Francis.
Ms. Francis, you are here in 26 CF 246, where you're charged with possession of a controlled substance, smuggling contraband, and driving while license suspended.
Yes, Your Honor. If I could
Mr.
get
Maddox
the
from the public defender is representing you. Go
Sorry,
ahead.
Your Honor.
Go ahead.
I'm just gonna look to see if she has an offer, Your Honor. Unless the state's able to beat me to it. Don't believe she did. But I'll just double check.
Have an offer.
No.
Okay. Adjudication of guilt, 2 years probation, 615 court costs, substance abuse evaluation, any recommended treatment, maintain gainful employment.
Plea is charged on the all counts.
Yes,
You
Okay.
said adjudication.
it would be an adjudication.
You're correct on convictions. You did. Okay. You understand that? Okay, so Your Honor, we'll have a resolution in this case.
All right, so Ms. Francis, what we're going to do is he's going to write that up as a plea form to go over with you. He'll come back and talk to you in the back, and then we'll bring you back out so you can enter your plea.
Thank you, Your Honor.
All right, we'll see you shortly. Gerald Gant.
Ms. Francis.
Anyone seen Mr. Gant?
Your Honor, I don't have anything on Mr. Gant. They did tell me he was released from the jail. I would just ask the court to check and make sure he was notified of this court date.
All right. The best I can tell is he was given a signature bond on his felony warrant. And so he bonded out before he ever probably even got to the jail. The warrant service paperwork says court will be at this location, but doesn't give either a date nor a time. So why don't we reschedule him for March 26th at 1:30 and send a notice to his address.
All right, perfect. Thank you, Your Honor. In the meantime, I'll try and get in touch.
All right, thank you. And there's an address there, because I don't see a phone number for it. Michael Jackson, Mr. Williams.
Good afternoon, Your Honor. This is Michael Jackson. I believe the case we're here on is 2026 CF 229.
We haven't handled this one
Judge, when I checked a couple of days ago, 43, and information had not yet, or at least was not visible on the court site.
yet. Let's see, it was filed yesterday.
So I'll enter a plea of not guilty on his behalf.
And that's trafficking in amphetamine or methamphetamine, 28 grams or more, and sale, deliver, possession with intent within 1,000 feet of a place of worship or convenience business. So it looks like 2 of the counts were dismissed, or not, no prost.
Yes, sir.
All right, when would you like to put him back? Is he already on the April 29th?
He's already on the April docket,
April
Judge.
29th at 9 o'clock.
Thank you, sir. All right.
All right, Leonard Jimenez Chava. Sure if I'm saying that. Oh, Mr. Dyer. I think it was also transferred from the south.
It was.
Check his other cases, see if he has them recorded. Looks like a written plea of not guilty was done by Mr. Dyram, and it's set for 4/27 at, we'll put it at 9 o'clock. And William Cohn, I think we dealt with that this morning, right, Mr. Williams?
We did, Your Honor.
Okay.
We did. By Mike. We did, Your Honor.
Thank you, Mr. Williams. All right. So did we already put him on April?
Yes, sir. I've got April 29th.
April 29th. Cohen, plea of not guilty was entered this morning. All right. Antarius McLean. Mr. McLean, you're here in 26 CF 248. You've been handed information showing that you're charged with felony battery, 3rd-degree felony. Do you understand that? Are you going to hire an attorney?
Yes, sir.
Okay, you're going to hire your own?
Yes, sir.
You don't want me to talk to you about appointment?
Yes, sir.
Okay. I'm going to put you down for April 27th at 9 o'clock. Make sure you give that court date to your lawyer, and I'll see you back that day. We have not guilty entered on his behalf. Kristen Miller.
She's in custody, sir. Miller, and then right after her be more Chisholm. If you want to jump down to Veronica Sandifer, she's out of custody.
Okay.
And then we'll get these other two. Do I have Miller? Okay, I got Miller.
All right, Miller.
Miller?
Mr. Williams, this was Miller. And Miller, 26 CF 317, charge of vehicle theft, 3rd-degree felony.
Yes, sir. I'll enter a plea of not guilty on her behalf. Request 15 days of pre-arraignment motions and trial by jury.
April 29th at 9 o'clock. Ms. Miller, be your next court date.
I'm sorry, Judge. I was.
4/29 at 9 o'clock.
Thank you, sir. All right.
Is this? Christopher Mora Chisholm.
Yes, sir.
Chisholm, you're here in 26 CF 266, where you're charged with 15 counts of possession, control, or attempt viewing any material which includes sexual conduct by a child, and also Appears to be 10 counts of possession of image involving animal sexual activity. Mr. Williams?
Enter a plea of not guilty. Request 15 days for pre-arraignment motions. Trial by jury.
April 29th, 9 o'clock.
Thank you, Judge.
Veronica Sandiford? Information file?
I don't know.
State?
On the
Information on Veronica Sandiford?
There should be a 1 count information of vehicle theft.
There should be.
I don't have an information file Drew, on Sandiford. There's not one file.
Are you local, Mrs. Sandiford?
No.
Looks like you came back from with the Valdosta.
I can't do it right this second.
Could it possibly be done this afternoon?
Yes.
Is there someone to swear to you?
Yes.
Can you stick around and save yourself a court date, Ms. Sandiford? I'm gonna get them to do that, and then we'll bring you back up. Just tell Ms. Rivers when you finish that, so we can get that going. I don't want you to have to come back just for me to hand you a piece of paper and say, we'll see you again in a few weeks.
Thank you.
And obviously, Ms. Rivers, if you have to file anything as far as Zoom and or leave an appearance, you can do that. All right, that's the end of our arraignment docket. All right, Mr. Williams, I'm not sure, sorry, Mr. Charles Williams. I'm not sure if someone's told you, you were appointed last week to a case that was set for a pretrial detention motion today, and that's the Arnett case, right? Carson Arnett.
Yes.
Well, and from my understanding, talk to the state about how we can change this up a little bit to make sure, because it's not often that private attorneys end up with pretrial detention hearings, but we've got like 4 co-defendants. We've already had 1 hearing on one of them last week. We had 2 more set for today. But I believe.
Yeah, it looks like you appointed me on
February 26th.
Thursday.
Yeah.
My assistant was out. She called me.
I'm not
while
upset
I was
about it,
away
Mr.
here.
Williams, other than I want to make sure in the future, Mr. Sprouse, if your office would have an objection to doing a notice of hearing on these types of things, when I tell you, because we have appointed counsel who isn't normally here on these types of hearing dates. That way we don't have these problems in the future.
Yes, sir.
And again, I think it's just a notice issue that things have to be done differently.
Yeah, I guess.
So, there's, Mr. Nopes was appointed to another co-defendant, but he is the same boat as you, Mr. Williams. He's available for tomorrow, so we're trying to bring him back for tomorrow to not have someone sit for another week in jail. Would that be at all possible for you?
Not tomorrow. Tomorrow morning?
Yeah.
I could do tomorrow morning.
I can accommodate. I'm trying to do whatever I can to get
Yes.
everybody accommodated as much as I can, because we've already continued this a couple of times in order to get lawyers
9
on.
a.m. would be fine.
All right, we can put you
That'd be
on.
fine.
And state's here already.
Okay.
Good. That works, Judge.
Why don't we bring up Mr. Cunningham and Mr. Arnett so we can tell them we'll have their hearings tomorrow morning.
May I let my cop go?
Your officer is free to leave, yes.
Yes. I'll get you a your email.
Arnett?
Arnett first?
If Mr. Williams will be you. All right, Mr. Arnett, this is Mr. Williams, who's going to be representing you due to the fact that he didn't get a whole lot of notice about today. We're going to bring you all back tomorrow morning and have the hearing tomorrow morning instead of waiting another week.
Yes, sir.
I really want to get this one done, so that's what we're going to do. And the court apologizes about the,
Tomorrow at 9 a.m. What time, if I could ask the deputy, what time do y'all expect to have them here? So maybe I can have a few minutes to talk to him in the back once I review everything. You're not sure? Okay.
I mean, 10 minutes is usually a safe bet, but depending
Okay.
on what happens at the jail, they get here.
I'll be here early and I'll check with you.
I appreciate it, Mr. Williams.
Just need to go run and print a score sheet, Judge, I know I have hearings too, but
Say again.
just need to run and print a score sheet, Your Honor, to resolve this. Okay.
Thank you, Your Honor.
All right, thank you. Are y'all ready to handle your other case for the 2 o'clock docket? It's a little early, but.
I'm ready.
Okay. If you want to step over just a second. Mr. Cunningham? Yeah, no, you're good right there. I was telling him to go over there, just because he's representing someone else and I don't want to be confusing. So there was just a little bit of an issue with getting your lawyer here, so what we're going to do is come back tomorrow morning at 9 a.m. We're kind of moving a lot of things around to make sure it happens tomorrow.
Yes, sir.
Instead of putting it off another week. So I apologize for that. It's just kind of the nature of getting lawyers appointed and catching up to speed as fast as possible. So your lawyer's not here. He's actually in court in the South End right now. So, but he will be here tomorrow morning at 9 o'clock.
Yes, sir.
All right, thank you, Mr. Cunningham.
You too.
Again, court's apologies. Yeah, Mr. Morris. This is just the, and that one's probably better since he'll be over there.
Stand over here, yeah.
Mr. Williams, this is just the,
The motion I filed to get an investigator
Investigator.
appointed. And,
we'll get him, be here in a second.
More.
So this is Tyshawn Morris. He's here in 4 different cases. It's going to be 22 CF 1436, 23 CF 2394, 25 CF 1174, and 1175.
yes, Your Honor, I have filed a motion with the court to have an investigator appointed. And I had asked for.
In which case? Is
in
it all of them? Is it
No,
4
just
of
the
them?
2 new cases, Your
The 2
Honor,
new
1174 and 1165. But frankly, Your Honor, the other ones are VOPs, and the VOPs are based upon
Yeah, yeah.
the facts that are in 1174 and 1175.
Okay.
So I had
And the reason I had a little bit of concern with, I think you asked for
80 hours.
80 hours. The one case is a possession of more than 20 grams of marijuana. And I understand the other case is a trafficking of cocaine case, so that's got some issues to it, I'm sure. But 80 hours, I just don't want to be in a situation just because I say you can do up to 80 hours, your investigator may do 80 hours when maybe 80 hours aren't needed.
I understand, Your Honor.
Trust me, I don't want to be involved in the financial part of
No, I
any of this,
understand. And-
but I also have somewhat of an obligation to
Sure.
make sure that I'm not just, you know,
And I'm sure.
writing blank checks on behalf of the state of Florida.
You saw that I attached the response from JAC with regard to the finances.
Yes.
I'll tell you, Your Honor, why I asked for 80 hours.
Okay.
Because I've had 2 or 3 cases over the last several years. They're
Okay.
very rare, where 40 hours wasn't enough.
Okay.
And then what happened is I have to file the motion again, send it to JAC again.
Mhm.
They review it, which is a 2 to 3 week process again, and then get it back to you. But I'm fine with doing that. I just don't want to be, I don't want to delay anything, because as you know, as a private attorney, it's already been handled by the public defender and then the regional counsel. We typically come in kind of late. We want to, and you know, in the court, we don't want these cases to
Language.
grow any extra age on them, and so I want to get it done without delay. But I'm happy to do 40 hours. Very, very rarely does my investigator need more than 40 hours, but if we put 40 hours and we need it, we can always go through that process.
Well, and part of the reason for the hearing was like, tell me why this is kind of an extraordinary type of case, because I would think 40 hours would be enough. It looks like it was
It
was
most
an
likely
arrest
will
warrant
be.
on the first charge, and when they arrested him, they found the new stuff. So,
Yeah.
or am I wrong on that?
This was there was a little bit of a chase involved, so there's some going to the scene kind of stuff to be done. Typically what I do, Your Honor, you know, is have my, once my investigator reviews the discovery, we'll meet and then we'll meet with the client, go over possible defense witnesses, any that might need to be tracked down, that kind of thing. And I will tell you this, if there's body camera or dash camera or any audio, that sort of thing, I'll have my investigator go to the jail and go over that, play that for the client, because they have no other way to review that discovery. They don't have access to any kind of audio or video devices that they can use. So, yeah, I agree with you, Your Honor, that probably 40 hours is enough. And if you like, I will be happy to amend my motion to you to ask for the 40 hours.
Did you send over an order?
I did, Your Honor.
Let me see if I can, it's in the system from you.
I believe your JA had it.
Here it is. I should just be able to edit it. Here. Well, I've made it 40.
That's fine, Your Honor.
All right, thank you, Ms. Williams. I'm signing the order right now. All right, order signed.
Very well,
Should be
Your
sent
Honor.
to your office this afternoon.
That's great. My investigator and I are about to head out to the jail to visit Mr. Morris and a few other people.
Okay, perfect. All right, then we will see you back tomorrow morning. I appreciate that.
You bet. Thank
Have a
you.
good day. Thank you, Mr. Morris. All right. Mr. Durrell and Mr. Swiatek, you kind of walked through the door at the same time. I'm not sure if y'all have talked about what you need, what you've got. Swiatek, I think you have Daryl Watts.
I do. Mr. Watts is here.
Mr. Watts, come on up.
And record, this is Glenn Switek for Darrell Watts. It's case number 04 CF 1557.
We're here about the termination date on probation.
No, Your Honor, we want to hold back on that and just hear the motion to modify or clarify. We'll save the termination for another day.
Go ahead. Well, about clarifying prior orders or something as far as the termination date, but I'll let you go ahead with your motion then. Which motion, what day was it filed?
This is filed November 13th.
Okay, I'm looking right. Just wanted to-
And we thought we were going to have this worked out with the state, and we didn't proceed with that hearing back last year. But we want, for one reason or another, we're here today. Mr. Watts has been having some problems with probation. And I think we need an order to clarify what it is he's supposed to do. And maybe what he's not supposed to do. I point out to the court, first off, that in the final judgment, which was signed, ordered on August 4th and signed on August 17th.
Of 2004?
2005, yeah.
2005.
He was to receive probate, well, apparently, this is not clear, and it might be an issue from when we do that motion to terminate probation. But he was placed on 30 years of probation, and it looks like, as a condition of probation, that he was to serve 82.65 months in DOC. The way it's worded, that's how I would read it. Which means that he would be entitled to prison credit against that probation sentence. I'd also point out to the court, which is more germane for today, paragraph 13 of the final.
Where are you reading that? I'm looking at the judgment of guilt and placing defendant on probation from August 17, 2005.
Yes, sir.
That says you are hereby placed on probation for a period of 30 years consecutive to 82.65 months prison. Is it written somewhere differently somewhere else?
No, but that's my read on it, right?
Okay, so it's consecutive to. Which would say the probation starts once he finishes his DOC sentence.
Yeah, but his maximum exposure was 30 years on each count. And this would make it 30 plus 8 if we go with that reading.
No, the maximum is 30 years prison or 30 years probation.
Right. And this, if we give it your reading, Your Honor, would be 38 total.
Do you have any case law to that effect?
No, sir, I do not.
That's why.
But in the statute about prison credit,
Which statute?
off the top of my head, I can't tell you. This research
It's your motion. It's
a
just
couple
one
of weeks
statute.
ago. But anyway, I mean, that's not why we're here today. I'm saving that for,
Oh, okay. So what are we here for today?
we're here to clarify the court's prior orders in this case.
Okay.
Because of the problems he's having with probation. And I want to point out that paragraph 13 of the order states that the victim was under 18, you have not successfully completed sex offender treatment program.
Which order? The
This
one I
is the
just
final
signed.
judgment dated August 5th and filed August 17th.
So it says, if the victim was under 18 years of age and you have not successfully completed a sex offender treatment program, you shall have no unsupervised contact with any child under the age of 18 unless another adult is present who is responsible for the child's welfare, has been advised of the crime, and is approved by the sentencing court.
But he has had this and completed the sex offender treatment program.
Do you disagree with that, Ms. Possum?
No, sir, I'm not
Okay.
exactly sure what Mr. Swatek is saying the problem is, because I believe Mr. Roberts is here and there's no concern.
What's the concern?
Well, what are problems you've been having with probation? What have they told you?
The main reason that we're here right now is because they're trying to say that when I go over to visit my parents' house, if it's more than 3 times in a year, it has to be a registered address. And I'm not spending the night there.
Your Honor, that's not a probation condition. That would fall under the statute 943.0435, and I don't believe the court needs to issue orders clarifying a statute that's in existence.
Ms. Possum, you happen to know what paragraph of that very lengthy statute you just said? That would be, I'm just trying to find it.
Not offhand. I may have my copy here.
All right, so 943.0435, 1F says that permanent residence, temporary residence, and transient residence have the same meaning as 775.21. On to 775.21. Guessing this is where the issue's coming from is paragraph 2N, as in November. Temporary residence means a place where the person abides, lodges, or resides, including but not limited to vacation, business, or personal travel destinations in or out of the state for 3 or more days in the aggregate during any calendar year. That is not the person's permanent or transient residence. For a person whose permanent residence is not in the state, the term also includes the place where the person is employed, practices a vocation, or is enrolled as a student for any period of time in this state. So if he's just visiting, how is that abide, lodge, or reside?
I'm not saying it is, Your Honor.
Okay.
Again, he hasn't been arrested for it, he hasn't been charged with that,
I think
so
what he's
we have
trying
no
to do is
basis.
make sure he doesn't get arrested for
Sorry,
it.
I'm not trying to interrupt. I'm just trying to get clarification. That way it's not happening on a repeated basis. Because I've been doing this for almost 15 years, and there's been a lot of things that I've had to almost fight. So we're just trying to get clarification.
Right, you own your own house, correct?
We are doing a rent to own, yes, sir.
And
And I do have a curfew.
How long have you lived there?
We have lived there for almost 10 years.
And you do visit your parents, they live here in Preston, right?
Yes.
And do you spend the night when you go to visit your parents?
No, never.
All right, so who's telling him something different?
Probation officer told you about the transient housing problem?
Yes, sir.
And I guess my problem is this clarification or me giving some sort of preemptive ruling on a violation or potential violation, which the court's not really supposed to say, well, if you give me a scenario, let me tell you if I think it's a violation of the statute or not.
That's our concern, Your Honor. They're basically asking us, hey, hypothetically this, what would you do with this? The statute exists as it exists.
Have they threatened to violate it?
Yes.
He just shook his head no when you said.
I don't think they have. He didn't tell me that he was going to.
Mr. Roberts is present, Your Honor.
Didn't they tell you you would be arrested if you spent?
That's what the sheriff's department says. That's what they're trying to say.
Okay, so the
And
sheriff's
that's
office
what
is
that
saying it'd be a violation of his SO requirements. Is that what I'm hearing? Well, now you're shrugging your shoulders.
Yeah, and if we had some specifics, we could.
Well, but I'm confused as to what I'm being asked to do. Your confusion as to what someone else is telling you that I don't know who that person is and what they've told you. But I don't think I can make preemptive rulings as to whether or not that's the case. Because, for example, if I do, am I going to put this in an order that he's going to carry around? And if some law enforcement officer tries to arrest him for a violation of his requirements, that he can say, well, no, I've already got the judge has said this. That's not really how I'm supposed to operate, unfortunately. But I'm not sure what I'm really being asked to do other than that.
Well, that's what I'm asking you to do.
Well, again, I have to stay in my lane, I think, Mr. Switek. Now, what I appreciate about this whole scenario is being advised that it's a possibility. So when a potential violation comes to me, or when I'm the duty judge like I am right now, if this were to come to me in front of with a warrant, I'd probably take a second look at it more than I might have, just because this issue's never been brought up before. That's why I had to ask Ms. Fossa, well, what statute are we talking about? What specific part of it? Then I have to go to another statute before I can make that decision. And frankly, unfortunately, I spend a lot of time doing research when I'm the duty judge because I get weird issues like this. But I don't think I can say, under the circumstances you've told me, I believe it's this or that. Otherwise, there's not, what we refer to sometimes as a case or controversy in front of me. There's no disagreement. There's simply, tell us what I can do and what I can't. But I don't think I can give a kind of advisory opinion like that.
Okay, well, if I can get back to my motion.
I'm sorry, what is your motion?
The motion to clarify and modify.
I thought that's what we were talking about.
Yes, but I'm not done talking.
Go ahead.
At paragraph 15 of the motion, the probation officer tell you that you have absolutely no contact with minors?
He has before, yes.
And when I look at the final judgment, if I can get back to that, at paragraphs 13 and 35. 13 says that if he's completed the sex offender treatment program, unless he's completed the sex offender treatment program, he'll have no unsupervised contact with any child under the age of 18. And when I jump to paragraph 35, it says that there shall be no unsupervised contact with the victim or any minors. But that falls under the middle of the page, the second page. Any probationer whose crime was committed on or after October 1st, 97, which this was in 2004, in violation of Chapter 794, sexual battery, 800.04, legal lascivious, 827.071, sexual performance of a child, 847.0145, selling, buying a minor for sexually explicit conduct, shall have these additional conditions, that's paragraph 35. The problem is that it conflicts with 13, and he was not convicted of any of those. He was convicted of attempt.
Your Honor, if I may, we may be able to shorten this a little. After I received this motion, I did have an opportunity to speak to his supervising officer, Mr. Connor Roberts, who is present, to clarify, and I believe I can proffer to the court, or the court can ask Mr. Roberts and yourself, that initially, at one point when he was speaking with Mr. Watts during the supervisory period, he indicated that he was not to have any contact with children based on the arrest of the offense that he was on, but he wasn't sure if he was allowed contact, so he was going to go check. So Mr. Roberts then verified that Mr. Watts could have contact with the victim, with children, based on subsequent orders that had been entered, and then clarified that with him so that he would know that he was allowed to have contact with those individuals. And I believe, if I'm incorrect, Mr. Roberts would correct me on that. But that would be, I'm proffering to the court that this is not an issue, that initially he was told he couldn't have any out of an abundance of caution. Mr. Roberts went back and followed up, realized that the court order said he could, advised Mr. Watts of that, so there should be no concern.
Well, there is a concern. If I have a probation officer who has the power to have me arrested, tell me that he will arrest me if I have any contact with minors, then it's a problem. And as you and I well know, probation officers change. Mr. Roberts is here within the next 15 years that Mr. Watts is on probation, well, then we don't have a problem, but that's not going to happen. So again, I would like an order clarifying that he can have contact with minors. And at 35.
I think it's very clear according to the order that you just read. The section that you're saying is inconsistent doesn't apply to him, right?
Okay, but that's what we need. That's what we need an order.
I don't think that's an order. That's an order interpreting an order. I'm sorry. Were you done?
Yes.
Okay.
That would be the state's position, Your Honor, because I believe, as I was trying to proffer on behalf of Mr. Roberts, that when he wasn't sure in interacting with Mr. Watts, he went back and verified what the actual order that was that applied to Mr. Watts, clarified it with him, so there's no concerns. We would certainly hope that any future probation officers would also read the individual's order prior to violating it.
And I think I can probably fix this a little bit, or at least explain a little bit. But there's a case that we're all somewhat becoming more familiar with through motions, the Gould case. That makes a huge distinction between attempt and whether or not something is the same sexual offense. And it's kind of turned around how we've done things for over 20 years. So I think there's a need to make sure everyone's comprehending it correctly, but I don't think it's a situation where I have to read orders and tell you what I think about them. The law is what the law is. If he doesn't fit under that category with paragraphs 19 through 38, then it doesn't apply to him and it's not inconsistent.
But wouldn't it be simpler for the court to enter an order saying 35 doesn't apply? That way he doesn't have to have this hearing transcribed.
You're asking me to clarify an order that's over 20 years old when it wasn't done at the time. I don't think it needs to be clarified. It speaks for itself.
Your Honor, obviously it doesn't, because he's been threatened with arrest.
Who's threatened him with arrest?
Probation.
That's which person?
Mr. Roberts.
Mr. Roberts, is that accurate? Do you want to come on up here? No, you just go to the Mr. Roberts.
Question: if I threatened to arrest Mr. Watts?
Yes.
To my recollection, I did not threaten to arrest him. I defined the various levels of contact with minors and said depending on which one he had, he could be arrested for having contact with a minor. That was prior to me recollecting and confirming that he is permitted to have contact with minors, supervised, unsupervised contact with his daughter, per court orders.
So what else needs to be explored?
Like I said, Your Honor, it would certainly be simpler to enter an order that says 35 does not apply for future probation officers.
Well, I haven't done that analysis. Does the state agree that 35 doesn't apply?
Not at this point, Your Honor. I mean, I'd like to go back and verify that as well. And again, we would oppose the court clarifying orders that do not need clarification.
Right, and looking at both the plea form as well as the judgment from August 17th of 2005, it says that he pled guilty to attempted capital sexual battery. But doesn't have a statute. So I don't know what was discussed at the plea hearing. Shouldn't it be whatever the judge said as opposed to what's in the written order?
That would be correct.
You have a transcript from 2005?
I cannot, but I can get one if it's available.
I think if I'm going to make that kind of potential analysis, I'd have to know what Judge Tolton had said during the course of the hearing, right? Because again, this is somewhat of a, in my opinion, a little bit of a sea change as far as what that Gold case does, as what attempt means or not. Is it a separate statute number that people are pleading under when they plead under attempt? Or is it a part of it? I think the statute has since been changed, but so some of these older cases have to be looked at. I understand that, but I'm concerned about making any kind of preemptive ruling on something. It's just not really what the courts are supposed to do, but I certainly would have to at least know what was said as opposed to, because I think there was a motion to clarify the order at some point, right? There's an order correcting sentence that was filed.
Your Honor, could you give me a spelling on that case you're referring to?
Gould, G-O-U-L-D. We'll give you a site if you give me a site. It's Florida Department of Corrections versus Gould, 344 Southern 3rd, 496.
Thank you, Your Honor.
And the opinion was written by now Justice Chandler. But again, without that other information, even then, I'd have to look to see, do I even have the authority to do what you're asking for as far as some sort of clarifying error as to, not error, order as to what something means. Because if it involves me looking at an old order and telling you what I think a potential violation is or isn't based on case law that came out 20 years later after the fact, I don't know if that's frankly the business of the courts at that point, to give advisory opinions or preemptive rulings. But I'm certainly willing to entertain an argument, and I just don't think that's what everyone's prepared for.
And then is it retroactive?
I want to read the Gould case.
That's all I've got, Your Honor.
All right. Thank you. So, obviously, I'm not going to issue the order you're asking for, but if you want to readdress it, I'm not specifically denying it. I just, frankly, I don't think I can make such a ruling, but I'm willing to listen to argument and authority as that I can, but also potentially reviewing the transcript of the 2005 plea colloquy. All right.
So the matter's held in abeyance?
Abeyance, I think, is a good word for it. Thank you, Mr. Swanson.
Thank you, Your Honor.
Information has been filed on Ms. Sandiford.
Ms. Sandiford, can you come back on up? As it was charged.
Yes, as charged. And the reason, my office had to do a little bit of digging for the victim. It wasn't clear on the offense report. That's why it wasn't filed yesterday. But my assistant.
The person who owned the vehicle that's allegedly been stolen was not listed in the offense report.
This is because it's from like Valdosta. It's Enterprise. We got.
Oh, it's Enterprise.
Yes.
All right. So, Ms. Sandiford, you've been charged with vehicle theft, which is a third-degree felony, and 26 CF 358. Ms. Rivers represents you. Go ahead, Ms.
We're
Rivers.
going to enter a not guilty plea and request trial by jury.
All right, I'm going to accept that and put you on April 27th at 1 p.m. And obviously, if you need a motion, if you're going to file a motion regarding Zoom or waive an appearance, you can certainly do so.
Thank you.
All right, thank you, Ms. Sandiford. Sorry for the delay. Mr. Durrell, are you ready?
Yes, Your Honor.
Oh, do you have another copy of the information to give to the clerk, or is that headed?
It's been filed.
It's been filed. You will. I mean, technically, it's the possession of the clerk. It just hasn't been processed yet. Sure. All right.
Good afternoon, Your Honor.
Good afternoon.
Please court Dustin Durrell. I'm here with Mr. James Kaufman, 24 CF 2783, Your Honor.
All right, Mr. Kaufman is here. There was a motion to dismiss you filed, and then the state filed a traverse last week. Have reviewed those things. Mr. Mooney, on behalf of the state, do you want to make any comment on your traverse?
I mean, based on the rules, Your Honor, if the state denies any of the allegations that are made by the defendant in their motion to dismiss, the court must deny the motion to dismiss. In this particular case, Your Honor, I believe that the defense is isolating one interaction between the officer, about the officer and what he stated during deposition. However, based on the totality of the circumstances and the entirety of the communication, the state believes that it is proper to present it to a jury to make that determination. In other words, I don't believe that this type of issue could even be decided at this level, especially because obviously there is this dispute of interpretation of the facts, and that by itself should be sufficient for presenting a case to a jury and let the jury make the determination.
Just to read over 3.190D, states a motion to dismiss under subdivision C4, which this is, correct, Mr. Jerome?
Yes, sir.
Of this rule shall be denied if the state files a traverse that, with specificity, denies under oath the material fact or facts alleged in the motion to dismiss. Do you have any argument regarding that?
Yes, Your Honor.
Okay.
So specifically, as Your Honor stated, and I think Ms. Leone said that if the state files a traverse denying any of the assertions or allegations, that's not what the rule requires. It requires the state file a traverse that denies a material fact. Your Honor, looking over the state's traverse, they essentially agree with all of the facts. I think they take issue with my legal reasoning and legal conclusions that I draw from attempting to apply the facts to the case law that I cite. I don't think a traverse is the proper method to address that issue. Specifically, Your Honor, the state admits all of the allegations in paragraphs 1 through 9. That's in their paragraph 1. The only thing that comes close, I believe, is their paragraph 2, where they state that they deny the allegations in my paragraph 10. However, if you look at my paragraph 10, Your Honor, I don't believe that can be a denial in good faith, as my paragraph 10 simply states that Special Agent Horn testified during depositions that nothing in the conversation, the November 17th conversation, constituted defendant soliciting, luring, or enticing. That's in the deposition, Your Honor. That is, I don't see how you can dispute a fact when that is what he said during deposition. Now, if the state is trying to say...
Well, but here's the problem with that, Mr. Durrell, is your motion in paragraph 10 doesn't say Special Agent Horn testified and then quoting exactly what he did. You're saying he testified that nothing in the conversation constituted defendant soliciting, luring, or enticing. I don't know exactly what was said, so your paragraph 10 is kind of a characterization of what the deposition says, isn't it? As opposed to a direct quote.
Your Honor, I believe I quoted him. I did not put quotations in the paragraph 10, and if that, what I was going to say, Your Honor, if that is an issue, or if that, the court disagrees with my assertion that that is a fact as stated in the deposition, I would ask for leave to amend. But it appears that, especially that second part of their paragraph 2, and yes, Your Honor, I can see where you're coming from, where I didn't put the direct quotes in there, and I didn't cite the deposition, and that is my fault. I thought about that when I was preparing.
And I understand, too, what you're saying is that he testified that nothing constituted that. Did he actually say that? Or are you saying that he said nothing that constituted that? It's kind of like, proving the negative, potentially. If someone didn't say something versus what did they actually say? Did he affirmatively deny that there was anything that constituted soliciting, luring, or enticing, or did you just, is it your claim that in reading it in its entirety, I didn't see him say anything like that, but maybe he was never asked that question? I don't know. I don't have the transcript.
I believe I attached the deposition transcripts. If I didn't, that was a mistake on my part. I know I meant to. I apologize, Your Honor.
No, that's fine. I want to make sure I didn't miss it.
I
The
know
motion
said
that I have
attached, but-
is.
So if I didn't, then that is 100% my fault.
Okay.
Again, I apologize.
Let's see. No, you're fine. Let's see. My motion that you sent me, that's filed, is only 5 pages. Was it attached? And
That
sent?
does not make it attached.
Okay.
And so, Your Honor, if this is an issue, I would ask for leave to amend so I could correct those issues, and I do apologize to the court. If you would like, I do have the deposition here. I can either read from it or let the court look at it, or like I said, if you would allow, I could do it correctly, and I apologize.
How long is the transcript?
The transcript without exhibits is,
And I guess even with that circumstance, Mr. Duro, even if the officer said, I don't think anything he said was soliciting, luring, or enticing, isn't that just the officer's opinion as to the testimony, as to the evidence, as opposed to what the actual evidence is? And I'd have to make my own personal determination as to what the evidence is or is not.
and well, at that point, Your Honor, again, and I thought that may be an issue as well when I received the state's traverse, if I could include the text conversation and apply the same legal reasoning and walk the court through the previous case law that looks at what somebody said when it was on appeal and ultimately overturned based on the issue of solicitation. So I think the court can legally or can apply a legal analysis to these undisputed facts, the conversation that was had between Special Agent Horn and defendant. Those are, in my opinion, the only facts in this case that are relevant to the offense charged. If I could include that conversation and apply the same.
Well, I think that's where it comes down to is the court has to make its own determination. Not even the investigator who was a part of the conversation, his opinion on whether or not it constituted something is it basically a call for a legal conclusion by a witness. And so I think I'd have to read it to make sure that I understand exactly what was said, and do I make a factual determination that yes, under the law, what was said is soliciting, luring, or enticing. And then at that point, am I making a factual finding whether that's really in the province of the jury to make?
I would still say that that's not a factual determination because, again, the facts are undisputed. It's just the words that were sent. This is all text communication that's all been downloaded, obtained through subpoena. The facts, you would not have to make a factual determination as to what happened. It would just be applying those facts, the words that were said, to the law as I provide, or as the state can, send in a case law if they find contrary to mine. Apply those facts, the words that were stated, to the law as determined by DCA or other courts that I can find, and make that legal conclusion and determination at that point just based off of, again, the undisputed facts. Which, again, I would ask for leave to amend and include it. I was operating under the assumption that the state's one and only witness said there is no evidence of the charged offense, the man that was responsible for initially determining probable cause to come to the court for an arrest warrant, said there was nothing there.
Well, again, I don't know what he said though. Not in the motion nor the traverse cite the actual deposition as far as what was said or what was not said or what was even not asked. Because I don't because if no one had ever asked the special agent that question during the course of the deposition, your assertion that he never said that would be true, even if, but right. not exactly accurate, because if he wasn't asked the question. But was he asked what is luring, soliciting, or enticing about what was said, and he gave an answer?
May I, Your Honor? Sure.
Just before you do that, the same paragraph I just read also says that the court may receive evidence on any issue of fact necessary to the decision on the motion.
Thank you, Your Honor. Just
No, it's fine.
Okay.
It's just that I'm objecting even to this, Your Honor. I'm objecting to the defense amending the fact that, oh, I didn't know the court was gonna look at it in that way. This is the point, Your Honor, is basically asking the court to review the communication, not the deposition. Deposition, as the court stated, is just the opinion of law enforcement. Solicitation is a term that is actually given instruction, the jury is instructed on that term because they have to determine whether or not a certain behavior or communication amounts to solicitation. So basically, in other words, it may be a good argument maybe for a JOA, but I don't believe this issue can be decided via a motion to dismiss because of the nature of what the defense is arguing. The particular officer believes about the law, they're not lawyers, they gather facts, and then we make the determination to go forward or not. So.
And yes, Your Honor, I do see that issue, and that is where I would ask for leave to amend to include that conversation as well. But as far as the actual deposition, just to make it through that, I asked, okay, well, if you could, on this conversation, would you be able to show me where the person later identified as Mr. Kaufman is soliciting, seducing, luring, or enticing you to provide an underage minor for sexual purposes? Special Agent Horn's answer, I don't think it's going to be on this thread, but let me just read through it real quick. No, there is nothing on this thread. And I follow up, okay, so this first conversation, you're saying there's nothing that would constitute seduce, lure, entice, or solicit, correct? Answer, from what I'm seeing, we discussed age, disclosed age, there was brief communication, but as far as any actually soliciting a minor to engage in sexual activity, no, I don't believe so. So that's what I was quoting from when I included that. And again, Your Honor, I apologize for not attaching the deposition. That was my oversight.
I guess I'm confused. It's your paragraph 10, Mr. Norrell, and it says, starts off with there's a second text message conversation between the defendant and S.A. Horn that occurred on November 17th. However, S.A. Horn testified during depositions that nothing in that conversation constituted defendant soliciting, luring, and enticing. So you're specifically only talking about the second conversation.
Which is actually prior to the November 17th. It's a November 15th into the 16th conversation, and then I believe it was a November 17th conversation. Special Agent Horn testified during deposition that the 17th was technically his first conversation that he had with Mr. Kaufman. He later used identifying features from that conversation, the email address, to identify another number that was associated with Mr. Kaufman. That's why we're calling chronologically first conversation the second conversation, because that was the second one he became aware of that dealt with Mr. Kaufman. A little obtuse, I understand, Your Honor, but that's where the two conversations are coming from. Originally, Special Agent Horn testified he had no idea these two were connected. He was digging into the November 17th, became aware of certain identifiers that matched November 15th and connected the two.
So, but when you're claiming that during the deposition, he's saying nothing in this text thread is soliciting, luring, or enticing, it's only about that one thread, not the other.
Correct, and that's the November 15th thread is the thread that I have cited in my facts. That's the conversation from the November 15th thread. And then I say there was a second conversation, the November 17th, that he testified there was nothing in there. And yes, Your Honor, I was working off the fact that the state's sole witness is probably going to testify that there is nothing in there.
All right, so I
said that I'm not going to address it.
So the focus of your motion is really just on the first conversation.
which is the only one Special Agent Horn identified as having solicitation language in it. So yes, that is what I focused on.
Let's make sure the phones are turned off. Well, I'll be honest, Mr. Durrell. Even avoiding the traverse issue, I think the conversation that's brought up from the first one, that there's certainly sufficient facts for the state to go forward and say that, and bring this to a jury that it's not a stretch of the imagination in any way that the facts that, as discussed even in your motion, or would be significant to talk about it being solicited.
Despite the Randall case, Your Honor, the crux of
I read it yesterday. Let me bring it up again. It's all right. Because I think was the Randall case the one with the overpass?
Yes, Your Honor, where the defendant essentially stated a desire, told this young lady what he wanted to do. And that's the argument I make in the motion.
But I think the factual differences are in the conversation that alleged to be your client talking to a special agent is talking about rates, talking about locations, making a selection as to basically who he's talking about, because there's discussion of a 14-year-old versus a 39-year-old. And after looking at photographs, he says the 14-year-old and asks for rate. And then he's asked, well, what specifically are you asking to do?
He's asked, what do you want?
Yes.
Similar to, and Your Honor, there's no agreement as to the rate. I do recognize that he asked for rate, but there's no, okay, I'll pay that. There's no promises made. There's no offers. There's no agreement in the end, Your Honor. So on top of that, I also
it doesn't have to. It's soliciting, enticing, or luring. It's not, making a contract. It doesn't have to be finalized in some way. There's a solicitation. There's of what is the rate that I have to pay you in order to have, and I'm now quoting directly from your motion as to what he asked for, is vaginal intercourse with a 14-year-old juvenile. I think that's solicitation. So you're free to file an amended motion, but at this point it's done.
Understood.
Thank you.
Thank you, Your Honor. I believe we are 427.
427, it would be at 9 o'clock. Yes, sir.
Thank you, Your Honor.
All right, Mr. Cobb?
Does I have the Rolandi Nelson motion on the
Yes.
docket?
She come on up?
Yeah, when I get down with this. Yeah.
What are they?
Okay. All right.
This is a response
That was filed.
Judge, for the record, Jason Cobb, I represent Edith Rolandi in 2024 CF 162. I did file a motion to withdraw. I submitted a proposed order to the court appointing alternative conflict counsel. Based on that, I believe a conflict does exist, especially when a client files a motion accusing her attorney of being ineffective. I think that's one of those things that rings a bell that's hard to go back from, and it makes it more difficult to continue to represent. So that's why I filed a motion to withdraw. In addition, I filed a response to the Nelson motion. I don't think that what I've done in this case rises to a level of ineffective assistance of counsel. I've tried to do everything I can to get the case resolved in a very favorable light.
Let's not get too ahead of ourselves at this point, but so I don't think filing a Nelson inquiry in and of itself is sufficient to be a conflict, but the issue is if I allow you to withdraw, and if you didn't do anything ineffective, then I have to talk to her about whether or not I can appoint her someone else. So I think there's still an evaluation that has to be done here of what her claims are.
Yes, sir, that's fine.
So, Ms. Merlandi, if you could raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Okay. Can you state your full name for the record, please?
It's Edith Elizabeth Rolandi.
And you can put your hand down, Mr. Rolandi. Thank you. All right, I've read your motion previously. I've now read Mr. Cobb's response that he filed yesterday. Have you had a chance to review that?
I did review it, and I also...
Well, I just want to make sure of that. All right, so now tell me what your concerns are with what Mr. Cobb has done or, in your opinion, failed to do in your case.
I wrote a statement because I don't want to ramble on, and I want to make sure that I touch on each point.
Okay.
Your Honor, may I read it?
If that makes it easier for you, go ahead.
Okay, thank you, Your Honor. Good afternoon, Your Honor. I stand before the court in the name of Yahweh of Hosts, the living
Ms.
Elohim.
Rolandi, I just want to hear what your claims are against Mr. Cobb. That's what we're here for.
Okay. Can I just finish this one part? Because it is who I am, so it's really important for me to see.
All right, I would just like to get through the hearing though.
Okay, so I stand with the God of Abraham, Isaac, and Jacob. That's all, okay? So I want to be clear at the outset that I'm not asking the court to decide the merits of my case. I am here solely for the purpose of a Nelson hearing and to explain why I believe there has been a breakdown in representation and my concerns are placed clearly on the record. During my first telephone conversation with the appointed counsel in April of 2024, we discussed the nature of this case at length. Because of our deeply held religious belief, my husband and I performed a covenant circumcision, which is to bless my son, not to harm him.
All right, let me just stop you for a second, Mr. Rolandi.
Yes.
And for no other reason than I feel I need to do this at this point.
Okay.
If you talk about the facts of your case,
Yes.
everything that you say can and will be used against you.
Okay.
Everything in this room is recorded.
Okay.
Prosecutor on your case is sitting over here,
Okay.
and they can write down anything you say. So
actually-
hold on, man. Let me finish.
I'm sorry.
I'm doing this because I have to do this. I want to make sure you understand that if you talk about the facts of your case like you just kind of did, then it could be detrimental to you. I'm not saying it will. I'm just saying it could be. And so I want to make sure you understand that before you continue.
Okay. No, I'm not ashamed that I performed a covenant circumcision on my son, because that's exactly what we did. It's to bless my son and not to harm him. I'm a registered nurse, and when we noticed something that prompted us to seek medical guidance, we brought him to a specialist, a urologist, who did not send him to the ER or perform emergent or urgent care. He evaluated him. He prescribed oral antibiotics, bacitracin, and sent him home with me with a 2-week follow-up appointment. Counsel asked about my religious background and acknowledged that the conduct at issue involved religious beliefs and practices. We also discussed that the Department of Children and Families did not pursue dependency proceedings, that my children were not removed, and that I never lost custody. That context was important to me because it reflected how the Child Welfare Agency viewed the situation at the outset. And we discussed that I'm a registered nurse familiar with signs and symptoms of necessary urgent and emergent care. He indicated at the time that the situation appeared to be a misunderstanding and that the dismissal might be appropriate. So moving forward to lack of investigation, because I did put it in 3 different sections. So lack of investigation. In that same initial conversation, we discussed the early sequence of events, including that incomplete information had initially been provided to law enforcement out of fear of family separation, that DCF deemed me safe, and that after additional information was provided to law enforcement Friday morning, the detective left, and later that night, law enforcement returned and I was arrested. I understood these facts to be important to the procedural posture of the case and to potential due process concerns. I needed counsel to help me understand and to investigate these issues. When the case was continued for deposition, I repeatedly requested that Dr. Weary be deposed because his testimony is material to the medical issues in this case. Yet that deposition was never scheduled nor completed.
Can I ask a question?
Sure.
Who's listed him as a witness?
We were supposed to.
Okay. Mr. Collins?
Dr.
Did she ask you to list him as a witness?
No, sir, I didn't list him as a witness because there was no need to have him at that time because I was working out with the state. I know that we deposed the doctors that she took her child to see, and they all stated that there was no permanent physical damage. And as a result of that, I filed a motion to dismiss, and the state dropped the charges. But
Well, hold on.
that's who she went to see.
They dropped it, they reduced the charges,
Reduced the
right?
charge,
Okay.
yeah.
I just want to make sure just to make sure the record's clear. This case has been going on for a couple of years, and I just got it a couple of months ago. So sometimes I ask questions, so I know the procedural posture of everything.
Yes,
Yeah, and I'll have to go back and look. I know that I deposed the witnesses I needed to depose to get the first degree felony dropped. That was the goal of that, and we deposed those witnesses. I'll have to go back and look about Weary. How do you spell that, Weary?
Wehry. He did evaluate my son as well. He's
So it sounds like he's potentially an expert witness, right?
he has over 30 years of experience.
Well, that's not, hold on. So in the law, there's a difference between fact witnesses and potentially expert witnesses. And doctors are often sometimes what we call, at least if they're a treating physician, a hybrid witness. They're involved because the facts are involved in the actual treating of a patient, but they're also experts due to the fact of their education and experience. So they're kind of a hybrid. Did this Dr. Weary, was he or she did he or she ever treat the child?
Yes, and he's a board certified urologist.
Okay.
So he specializes in the field that we're discussing in this case.
Right. Go ahead, Mr. Cobb.
Also, did I finish that part? Yeah, I turned it. Also, a material body cam video contains statements by the original detective raising concerns about prosecution, acknowledging the religious nature of the conduct. The footage was never reviewed with me, and its legal significance was not discussed with me. In addition to the investigative issues described above, I also experienced concerns regarding the preparation and development of my defense. I was appointed counsel in April of 2024. 15 months later, in July of 2025, the only substantive motion filed in my case was a C4 motion to dismiss. That motion was set for hearing on September 11, 2025. But on September 9th of 2025, 2 days before the scheduled hearing, the state amended the charges, and the motion was never heard. As a result, no dispositive motion has been litigated on the merits of my case. Before counsel was assigned, the state amended the charges to aggravated child abuse causing great bodily harm after medical documentation was provided indicating that my son has no issues at all. After counsel was appointed, I expected the legal and strategic implications of that amendment to be reviewed and discussed with me, but that did not occur in a meaningful way. I am not asking the court to evaluate the merits of the amendment today. I reference it only because it affected my understanding of the case and preparation of my defense. A pretrial intervention offer was extended by the state on or around November 15, 2025. I requested that appointed counsel request the state to clarify and place on the record the factual basis for that offer. due to a discrepancy so that I could make an informed decision. He did say that he made the error in facts, but also stated that he would have it clarified. I have not
Let
been.
me just interject here. The state doesn't have to give a reason why they make an offer.
Okay.
So, I mean, it could be because they think there's a weakness in the case, they think there's justification to do that. They're not
Okay.
required to give a reason on the record. Oftentimes, the court will ask the state if there's anything they want to put on the record as to why they've offered a particular settlement, plea agreement, whatever you can call it. But that's just giving them the opportunity to do so if they'd like.
I appreciate you explaining that. I'm
Sure.
not really, too familiar with
I understand.
court law. So I have not been informed if this occurred. In addition to concerns regarding preparation, I have also experienced ongoing communication issues that affected my ability to meaningfully participate in my defense. There were multiple hearings where appointed counsel was unavailable and substitute counsel appeared in his place. On some occasions, substitute counsel was not familiar with my case.
Let me ask you this, what type of hearings are you referring to?
Well, some pretrial, but there was one specific, which was November 17, 2025, when Attorney Nopes covered for counsel and Judge Stone asked for me. My husband was there and made the court aware of the agreement I have, and Attorney Nopes said it was docket day. Attorney Nopes stated that Mr. Cobb had planned to be there that morning, but had to go to a medical appointment with a family member and needed to have this case continued. Judge Stone had it in his notes that it was set for plea or continuance that day and requested Attorney Nopes to contact Mr. Cobb. I missed the docket day hearing because I was not informed that my attendance was required, which created a risk that I could have been held in contempt of court. Mr. Nopes returned and notified Judge Stone that Mr. Cobb hadn't had a chance to talk with me since last pretrial, and he believed the state was fine with continuing to next pretrial, and the next hearing was set for status. These events contributed to my concern about communication and affected my ability to meaningfully participate in my defense. I primarily communicated with Attorney Jason Cobb by text message, as he advised during our initial conversation that this was the best method of communication. I sent messages requesting communication or assistance on the following dates without receiving response. Would you like me to read all the dates?
If you feel the need.
August 26, 2024, January 3rd, 2025, February 6th, February 10th, February 24th, March 4th, April 10th, April 14th, May 29th, May 30th, July 16th, September 5th, September 8th, September 9th, September 10th, September 11th, September 26th, October 9th, October 23rd, October 27th, December 8th, and December 17th. And there were 3 unreturned phone calls, which include September 9th, December 10th, and December 11th, 2025. In written communications, counsel advised me that the state viewed my husband as the party most responsible for the situation and indicated he was comfortable with that posture. He's my husband. We are a family of 7, which we would be affected. That would make me a widow and my children orphans. While I understand counsel...
I'm sorry, what?
So he was fine with my husband. He said that the state viewed my husband as the party most responsible.
I understand, but how would that make you a widow when your children are orphans?
Well, if for some reason the state, if for some reason my husband did get convicted, I would be a widow and orphans. My husband would be taken away.
Well, okay. I don't think maybe the definition is different than you think it is.
That's the biblical definition, so that's what I go by.
But just because even if someone were to be convicted of a crime doesn't mean they're even put in jail. It's a possibility,
Okay.
but it doesn't mean it's necessary.
Okay.
So I understand your concern, but you have to focus on your case.
Okay.
And his job is to focus on your case. If he were to focus on someone else's case to your detriment in some way, that would actually be something that would be improper for Mr. Cobb to do.
Understood, Your Honor. While I understand counsel must provide candid advice, that communication, together with the other issues I've described, contributed to my concern that my individual defenses and concerns were not being meaningfully considered. Taken together, these issues resulted in a breakdown in the attorney-client relationship. It impaired my confidence in receiving effective representation. Your Honor, I am not offering these statements to argue the facts of the case or to ask the court to weigh evidence. I am explaining why I believe these critical issues have affected my confidence in representation. For those reasons, I respectfully request that the court conduct a Nelson inquiry.
Okay. Are you asking for another lawyer to be appointed to you?
I'm not sure. I've thought about it a lot.
Well, I hate to be this way, but I kind of need that answer. Because it changes what we're here for. The Nelson inquiry is saying, this lawyer hasn't done what I've asked him to do, and I want someone else.
Okay.
As opposed to, if you wanted to represent yourself, we'd have to go through what's called a Ferretta hearing. It's a little bit different.
So did you make a decision as well as why, like if he was effective or not based on
I haven't yet. I'm trying to make sure that I even need to do that.
Okay.
Because you've asked for him to be removed from your case. He's asked to be removed from your case.
Well, I didn't necessarily ask for him to be removed. I just said.
Well, then what are you asking for? I hate to interrupt, but I have to know these things. But my job is to determine based on what people ask for and not do things that I just want to do on my own accord.
Well, do you think that he's been effective?
I'm not making that decision at this point because now, based on what you've told me, I have concerns as to what we're really here for. What are you asking the court to do? Appoint you a new lawyer or not?
Well, I wanted you to hear all the issues that I've had with my.
And I have.
And isn't a Nelson inquiry for the judge to decide if the lawyer is effective or not?
In order to replace him or her with someone else.
Oh, so.
As far as effectiveness, that can be done, in a post-conviction potential claim. It can be done through the bar. I mean, there's all sorts of different ways that these things are handled. My role in a Nelson inquiry is, has he done something ineffective to the point that I have to give you a different lawyer? But if you're not asking for that.
Do you think that he has? Do you think that?
Ma'am, I need an answer.
Oh, because I thought that's what. See, I'm not too. The way that I understood when I looked it up and read about it, I thought the judge makes a decision of the effectiveness.
As to whether or not your lawyer will be replaced by another.
Oh.
Because if you're saying you want him to still be your lawyer, it changes things. If you're saying I want someone else, that's what we're here for.
Right.
If you're saying I want to represent myself, that's a different type of inquiry.
Right.
Because frankly, now that I've heard what you've had to say, I'm not quite sure what you're really asking for, and that changes the analysis.
I understand.
So I would need to know what you're seeking in order to make a proper decision.
Judge, can I say something for a second?
Go ahead, Mr.
When I got a copy of the Nelson motion, I emailed Ms. Rolandi and I told her I read it. I said, I hear what you're saying to me. Let's meet, let's talk and try to resolve this because I still would like to represent you in this case. And she emailed me back and said, I think that we're going to wait and see what the judge has to say about it. So I did try to reach out to her, did try to talk to her about these issues. I would like to respond to the issues, but I'll let her answer the question the judge is trying to get at before I respond.
I think it's important, Mr. I wouldn't ask it if I didn't think it were important.
Right.
Because if you filed this and he tried to talk to you about the issues and you basically said, I don't want to, I want the judge to make a decision on it.
Well, I wanted it to be presented before you to see if, because I don't understand the law, and when I looked that up, that's what I understood it as, the judge will make a decision as far as the effectiveness of your lawyer, so I thought, okay, let's
with
present
the
it
intent of appointing you a new lawyer or not.
So that's what I was missing. Well, if writing all of this, I believe that this could have been taken care of in the first year, if that, even that long, like within the first couple of weeks. And so being here for over 2 years later, I mean, I wouldn't, you know, I don't think we should continue. I don't think he's effectively
So the question is,
represented me.
do you want me to appoint you a new lawyer?
You know, the Bible tells you that Yahweh, which is God, never will fail you. Put your trust in Him and not in men. And look what's happened. So at this point, I'm going to say no.
All right, so basically you're just asking for him to be off your case.
Right.
All right. So what I'm going to do is I'm going to grant the motion to withdraw. But what we're going to have to do, Ms. Rolandi, is go through the entirety of what's called a Feretta hearing, since you're not asking for another lawyer.
So then what's, I don't understand this.
I don't understand what you're holding
The
up.
Nelson inquiry, since you didn't even end up making a decision on it.
I think I've said this numerous times now, Ms. Rolandi. The purpose of it is for taking him off your case and then appointing someone else.
So then you approved his withdrawal instead of approved my Nelson inquiry?
I can't keep explaining it, Ms. Rolandi.
Okay.
You don't want him on your case. He said, based on the conflict that's arisen because of this, that he shouldn't any longer be on your case. In order, the purpose of making a determination is to whether or not you're allowed to have someone else be appointed to you. But if you're not asking for that, why am I making that determination? Other than you want me to make some sort of determination that your lawyer's done something wrong because you think that's going to help you with your case in some way.
No, I just thought.
Then
like,
for what is the purpose why you want the court to determine that?
it just felt like undone, like it's not completed. Like I brought this before you and it's just, I don't know, for my job, we like.
Well, this isn't your job, Ms.
I know.
Blondie, it's mine.
I understand that.
And I do this all day, every day. So what I'm telling you is the reason why I do these inquiries is when you ask for that is to make that determination. But I'm not going to make some sort of determination that something's gone wrong in your case because it's not at that point where I can make it a determination where that would really matter.
Okay.
For example, ineffective assistance of counsel is something that can be brought up as a post-conviction motion under 3.850 to determine did he do something, did a lawyer do something that caused some sort of adverse consequence or your case didn't go well because of what something they did or failed to do. Your case isn't over, so how can I make that determination?
Okay.
So the purpose of the Nelson inquiry is, should I kick him off your case and give you a new lawyer who's going to do a better job? And since you've said you don't want another lawyer, why am I making why am I making that decision? The court has to, again, stay within its lane, right? So I'm not going to do something if it's not necessary to have done. And since you're not asking for another lawyer, and it seems to be both sides have made a decision that there is conflict here, that your attorney-client relationship is broken down, then I can allow him to withdraw with your consent, seemingly, that he's not going to represent you. Do you understand that?
I do.
Okay. So I'm going to allow him to withdraw. But in order to do the Feretta inquiry, I think we're just going to need some time to do that. I know we've got some other cases, including your husband's case, that we still have to address quite a few things. And so what I'd like to do is take care of some other cases, and then if we've got the time today, I'll certainly go through the Feretta inquiry with you. It's just a lot of questions about how old you are, how far you've gone in school, have you ever represented yourself, do you understand the rules of evidence, and those sorts of things. And I can go through that, but I want to make sure I'm handling all the other cases in turn, because that wasn't set for today.
I understand, Your Honor.
Okay. So if you don't mind, take a seat and I'll recall you up if I have the opportunity to do that today.
Okay, thank you.
But otherwise, Mr. Cobb, you want him off your case.
I guess so at this point.
Okay. All right, thank you. You're free to go.
Judge, when you approach on an unrelated case
Sure.
quickly with Mr. Sprouse.
With Mr. Cobb?
Yes.
Oh, okay.
Do you want to handle this recall of plea?
Yes, if we could handle that.
Yes, Your Honor.
Let me see who else is left.
That'd be for me, Cutter Ford, and Del Rose on the Nelson hearing today, Your Honor. Cutter Ford is a competency hearing. I can go ahead and give the court a copy of that report.
I've reviewed it already, and they sent it to me.
It'll be a stipulation.
Let's get Ford, if we can do that one.
That's fine.
Francis?
So, Your Honor, this is Miss Francis recalled again before the court in 26 CF 246. Your Honor, I've gone over this plea agreement with her, and I've gone over her score sheet with her. She does understand that she's quite close to scoring prison, so even if she were only to pick up a technical, she would be over that threshold. That being said, she does want to enter the plea, Your Honor, if I may approach.
Yes.
Yes, right there on the
About
line.
as close as you can get.
Yes.
All right, Ms. Francis, can you raise your right hand? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right, can you state your full name and date of birth, please?
Voting Suzanne Francis, 10/30/66.
Thanks. All right, so you're here in 26 CF 246, where you're currently charged with possession of a controlled substance and introduction of contraband. Both of those are third-degree felonies, punishable by up to 5 years in state prison. You also have a drive-while license suspended or revoked, which is a second-degree misdemeanor, punishable by up to 60 days in county jail. Do you understand that?
Yes, sir.
All right. I've been having a plea and sentencing agreement that calls for you to plead nolo contendere on all three of those counts. In return, the agreement you've made with the state would be 2 years of probation on counts 1 and 2. Count 3 would just be time served and adjudication of guilt. It'd be adjudication of guilt on all 3 counts, which means you'd have 2 felony convictions from this. As part of your probation on counts 1 and 2 would be a substance abuse evaluation and any recommended treatment. Your probation would be concurrent between the counts. $615 in court costs, $150 cost of defense, and I'd waive cost of supervision due to the fact that you've been found indigent by the court. Is that what you want to do here today?
Yes, sir. Yes,
Have you had enough time to go over this plea form with your lawyer?
Yes, sir.
And did you understand and sign it?
Yes, sir.
And are you satisfied with his advice and representation?
Yes, sir.
Are you currently under the influence of any alcohol, drugs, or controlled substances?
No, sir.
Are you currently suffering from any mental health
No, sir.
issues? Has anyone forced, pressured, or threatened you in any way to enter
No,
this
sir.
plea? Just if you could let me finish, that way the microphone picks us both up separately. Otherwise, if there's a need for a transcript, it will be hard to hear. All right, and has anyone promised you anything other than the terms of the agreement that I just announced?
No, sir.
And do you understand that by entering a plea, there won't be a trial of any kind?
Yes, sir.
And do you understand that you're giving up your trial rights, which are listed on page 2 of that agreement that you've signed?
Yes, sir.
And do you understand that you're waiving all potential defenses that you may have?
Yes, sir.
And finally, do you understand that if you're not a U.S. citizen, this could lead to your deportation or exclusion from the country?
Yes, sir.
All right, and based on all those things, what is your plea as to the possession of controlled substance, introduction of contraband, and drive-while license revoked?
No contest.
I'll accept your no contest plea as freely, voluntarily, and knowingly given. On count 3, it's going to be time served and adjudication of guilt. On counts 1 and 2, it'll be 2 years of probation to run concurrently, also an adjudication of guilt. Substance abuse evaluation, any recommended treatment, $615 court costs, $150 cost of defense, waive cost of supervision. Ms. Francis, I'm going to need you to speak with probation, who's sitting behind you there, and then once you're done with them, you'll come up to be fingerprinted, and then you have 30 days to appeal the judgment and sentence of the court. I will point out, I do have your score sheet here. Any objections to that score sheet, Mr. Maddox?
No, Your Honor, and it's been client outline.
All right, and so you score 43.80 points. 44 is the threshold where you're looking at a minimum prison sentence unless you can convince the court for what's called a downward departure. The reason I bring this up specifically is to say it's a guideline sentence, but however, even a technical violation of your probation, not reporting, not getting your substance abuse evaluation done, could lead to 6 points on your next score sheet if you were to violate, which means you would score prison. I bring that up to make sure you understand how important it is that you take your probation seriously and do not violate it.
Yes, sir.
Okay. Speak with probation. Again, you have 30 days.
On a competency hearing, Your Honor, the state and I are going to stipulate to the report and the court making a determination of competency based on that report.
Let me just pull it back up.
Yes, Your Honor.
The state has reviewed the report and stipulates to Your Honor using it for competency purposes.
I would also just go ahead and put on the record, Your Honor, I have personally spoken with Mr. Ford. I went to the jail yesterday to speak with him. After discussing his case with him, while I won't say he's perfect, I do not have any reason to doubt his competency or doubt this report, so I am comfortable with the court making its finding.
And the court's previously reviewed the forensic evaluation that came to the court from the Florida State Hospital and Dr. Renfro. It was filed on January 5th. Honestly, I had to reread it a couple times at the end about dates and things that
And with Mr. Sprouse and I.
yeah, it just seemed to be a little bit hard to track. But once I read it twice or three times, that I totally understood exactly what the timeline was. So based on the stipulation and my reading of the report, I am going to find that Mr. Ford is competent to proceed. If you could give me an order to that effect, Mr. Maddox.
Yes, Your
I'll
Honor.
get that signed as quickly as I can.
Will do. Oh, could we put him on, it is possible the case could be resolved on the 26th, but I understand if the court wants to just go ahead and set him for a pretrial conference in April, we can always set him earlier if we work something out.
We'll go ahead and put it for April 29th at 9 o'clock, but you're free to move it up if need be. I'm not sure who you are, ma'am, but he's an adult. I mean, you can try to speak with his lawyer, but you're not gonna.
If I may, Your Honor, it's his family members that are present. I've spoken to them as much as I can and am able to under the law with protecting the attorney-client privilege about the case and what was going on today. They have their own concerns. I'll address that outside the presence of this court, Your Honor. They've been informed of that. I've spoken to them, like I said, fairly extensively to the extent that I can, and I apologize for the interruption, quite frankly.
That's fine. All right. I can't have people yelling from the back row about things. He's an adult, he has a lawyer. That's what I have to keep these things to. You can certainly inform his lawyer of things, and he'll bring to my attention what's important for me to know. All right, thank you. 4:29, 9 o'clock, but again, bring it up earlier if y'all have some sort of resolution.
Yes, Your Honor, thank you.
What is it?
I'll come talk to you about, April 29th, sir. Yeah, but we may get it resolved before then. For today, yes, sir. Thank you, sir.
All right, thank you. All right, I'm going to handle Mr. Rolandi's case. Are you ready, sir? And then, Ms. Langley, real quick, on the one from this morning with Mr. Rare, you're agreeing to that stipulated order?
Yes, Your Honor, yes. And I apologize for kind of rushing, but it's because he will get out.
Oh, I know. No, I
Yeah.
appreciate it. I just, as you can see, I'm doing a lot of things.
I know.
I just want to make sure, I saw your email, but you're sitting here, I might as well ask.
Yes, Your Honor.
Okay,
Thank you.
hold on just a second. Let me get that signed.
Judge, forgive me. May I be excused?
Yes, Mr. Sprouse.
Thank you.
I apologize, Mr. Orlandi. I just want to have to sign this order so someone can get released from the jail based on a stipulation. I want to not have that not processed today and someone ends up spending an extra night in jail because of it.
No problem, Your Honor.
apologize for that. All right, this is James Rolandi, 24 CF 137. We're here for several other hearings, the kind of a continuation of what we had a couple weeks ago.
Yes.
So, Mr. Rolandi, they're your motions, so tell me how you'd like to proceed.
Good morning, Your Honor. Good afternoon, rather, I'm sorry.
I did the same thing earlier, so.
Yeah, I haven't really eaten much, and I tried to run my whole route so I could be here today on time.
Okay.
I'm sorry about my wardrobe.
No
I
worries.
had to choose accordingly.
No, you're fine.
We did the notice of filing, and we wanted to start with the Richardson.
Okay, let me,
I just kind of had points. I don't know if you want me to read it or just kind of go over the points
all right,
of the
let me
Richard.
pull it up again. So what I'm going to have you do, if you don't mind, is kind of go through the individual issues, and I'll hear from the state on each of them, as opposed to you doing everything and then have them respond
Sure.
to everything. So let me just pull your case back up and I'll open your motion. I reviewed it again yesterday, but I want to have it in front of me while you're talking. You remember approximate,
I know the entries. I wouldn't, once
when was it filed?
the notice of hearing,
No, just the actual motion.
I pulled it up, I'll get it.
Do you recall, Mr. Rolandi, when you filed that?
It's in the notice of hearing here. I filed it all in. I'm sorry, I was
I
looking at
thought I
something
had
else.
written down all of the DIN numbers so I could quickly track them, and then for some reason I don't have that in front of me.
1/12/26 is the Richardson motion.
Index 169, Your Honor.
Correct?
I've got it. That's the same one.
Yeah.
All right. All right, go ahead, Mr. Rolandi. I've got it
Okay,
open.
so just kind of walking back, in my case with the first undersigned attorney, a notice of discovery was filed January 23rd, 2024. That was Mr. Koch. Shortly afterward, February 1st, 2024, Mr. Switek filed notice of participation in discovery. There were many complications where the state posted on the clerk site that we were receiving discovery, but the files were not being made available. We, as the defense, offered up our evidence March 12th, times 2. We did 2 dumps. And April 25th, 2024, we submitted all the medical files for ENR, which consisted of Beachside Pediatrics and Dr. Mark Weary's assessment. So those were the initial very pertinent medical findings that were shared. Just kind of making sure that the state concurs with that.
Yeah,
You know,
I
you're
received.
new to the case too.
No. I received and I concur with what Mr. Rolandi is saying.
I see on that date, April 25th of 24, the reciprocal discovery, which was filed by the defense, says ER medical records, and that's ER the initials for the child, right? Not
It is.
emergency room. Right?
ENR, yes, sir.
Well, it just says ER on here, that's fine. I mean, you said ENR, but on this it says ER, so I'm just making sure that I'm reading that right. And it says from Beachside Pediatrics, but I don't see the name of that doctor listed. Are you saying his report was a part of that? Or whatever he did was a part of that?
One of those 3 dates, because there's March 12th, and April 25th, it is in there. I just looked at it.
Oh, here we go. There it is. Okay. Sorry, there was 2 filed on the same day, and I only looked at one of them. So on DIN 48, it lists Beachside Pediatric Custodian of Records as well as Dr. Mark Weary, W-E-H-R-Y. Go ahead.
Yes, Your Honor. So there was discrepancies about what was being shared with us from the state. And we would say we're not getting it, and they're saying, well, we had to take it off, it was redacted, it was placed back on. So we really didn't get the information all at
What
once.
specific information are you talking? I have to talk in specifics, Mr.
So
Orlandi.
we didn't get really body cam footage or written statements, affidavits until late March of 2024. So that was the initial dump. And then when I became pro se, in later filings, we informed the state of 2 very important pieces of evidence that had not been made available. An interview of the defendant in Okaloosa County Jail with Ms. Jacqueline Gonzalez on January 19, 2024, and an interview
Who's
with.
Jacqueline Gonzalez?
That's the DCF worker.
Was that recorded for some reason?
It was recorded in the prison, or the county jail.
Who recorded it?
I would believe that anything said in that room is recorded.
100% no. Those rooms are used for attorney-client conversations as well, so it would be basically illegal to be recording those rooms.
But it's not an attorney, that's DCF.
Yeah, but there's no recording equipment in those rooms. So that may be your concern, Mr. Rolandi, is if the room where you may have talked to them is not just recorded at all times. Because those rooms are basically used for certain type of visitation. Someone's visiting someone at the jail, like a family member, that's done in a different place. The rooms you're talking about, where you could meet with potentially law enforcement officers, if you're willing to talk to them, DCF, or your attorney, are done in those rooms, and so those are not recorded.
So the state is also concurring that there is no evidence that exists for that interview?
Other than what the
You're saying
other
from the stand, but
do you want me to answer?
You're going to have to key me off, because every time I talk, you interrupt me, so you're going to have to kind of key me to speak.
You asked a question, so I went to respond.
I'm saying, you're saying it from the bench.
Okay, you go ahead, Mr. Rolandi. When you're done, I'll talk.
No, Your Honor, this is your courtroom. I'm just saying, you'll ask me something, then I'll speak, and then you cut me off, and then this is hard enough as it is for me.
You asked a question. I tried to respond to it. We started talking at the same time, but I wanted to clarify that unless that person who did the interview recorded it in some way, which they typically don't, the only thing that would be a record of is whoever took notes about it. But you're going on this assumption that those rooms in the jail are automatically recorded, and they are not. And I can tell you, because I've had hundreds of client meetings in those rooms, and it would be improper for anyone to record those things.
I just want, because if you give me a gentle key, I'll know, because like if I speak sometimes. Then
When I say go ahead, that means you can go ahead and speak.
Okay, so is the state concurring that there is no interview for January 19th, 2024 between the defendant and Jacqueline Gonzalez?
I'm not aware of any recording of that interview.
Why do you think there is one, other than you think everything in the jail is somehow magically recorded?
There's just, I watched these shows all my life, and they would show different interviews being conducted by
Those are
people.
those are typically in police stations. They're done like that.
I just wanted to make sure that wasn't, because there was very pertinent information in that interview that is extremely beneficial to the defense.
I understand. Have you attempted to subpoena any records or anything like that from the person who interviewed you there?
No, Your Honor.
Okay, I'm just trying to put it out there. You're going on a kind of a false assumption that it was recorded, and I'd be shocked if it had been, and certainly if you're thinking that based on the room you were in, that's not how those are done. The ones you're talking about when you watch those TV shows, it's law enforcement officers are doing that inside of a police station or the sheriff's office or wherever it may be. Things could be recorded if someone took out a recording device and put it down and said, do you mind if I record this? But unless you tell me someone did that, I'd be surprised if it had been recorded. And I can tell you that I've spent time in 3 different divisions that handle dependency court. So I've handled hundreds and hundreds of dependency cases where those types of investigators and or caseworkers testify, and they never have recordings of things. Go ahead.
Okay, thank you. So we did that one, and then we did Detective Michael Wilson, which was made available on December 5th, 2025. We originally got all the body cam footage in late March of 2024. Okay. For some reason, this one just sneaked in about 1 year and 8 months later. All right. But we did get that, so we did, that was shared December 5th, 2025, we did receive that interview.
Okay, so Ms. Leone, again, you weren't on the case then either. So do you know any reason why that particular body cam wasn't turned over until then?
No, I don't know the answer. I'm assuming that probably came out in the position, and like it normally does. But we didn't have it, the state did not have it at the time. When we obtained it, because we knew it, then we shared it immediately.
You indicate in some way when you think your office received that?
Yeah, I can try to find out.
What was that day you said in December, Mr.?
December 5th.
I'm looking at the discovery exhibit that was filed on December 5th. It says FDLE lab report dated June 3rd, 2025, received on December 5th, 2025 with supporting emails. It doesn't say anything about body camera footage. I just want to make sure I'm not missing it.
It's November 2025, based on Mr. Rolandi's motion that he received the body-worn camera. The December 5th was the FDLE.
You've received it?
I've received it. Yes, sir.
So what are you asking the court to do?
I just brought it again it was just late because we had all the other body cam footage, so it didn't really make much sense to me why this one wasn't shared when all the other body cam videos were shared with the defense.
And what Ms. Leone has said is they didn't have it. Once they received it, they gave it to you.
I continue, Your Honor?
Yes, sir.
So after that, as the state, Ms. Leone just said, we did receive a DNA sample that was dated June 4th, 2024, which was also shared December 5th, 2025. The state says that when the DNA results were shared with the state, they shared them, but many of us know who have worked in the medical field that assuredly when the results are ready, they are shared. These results were pertinent to early case proceedings. So it was dated June 4th, 2024. And in the medical field, if you get like results, blood work, they're not going to share it with you a year.
This isn't the medical field, sir.
I was an EMT for 5 years.
This isn't the medical field.
No, I'm saying the medical field, when they share results, are not going to wait a year and 6 months to share.
You're talking about an FDLE lab report.
Yes, sir.
FDLE is not a medical agency.
Your Honor, what we're saying is that the results were dated June 4th, 2024, so this was very pertinent to us
It says June 3rd, 2025.
If you read the results, though.
I don't have it. So does someone have it? Just so you
um,
understand, Mr. Orlandi, when they submit an exhibit that says, these are what we're turning over, that's the only thing that gets filed in the court. The actual exhibits do not. The actual documents that are saying they're turning over, so I don't have a copy of it. And I know that's, a lot of people have that kind of misconception that the court somehow has access to all of these reports and videos and things. I don't. The only evidence I look at is what's given to me in a courtroom.
I'm going to just look right here for you very quickly.
But if I may, it still needs to prove some kind of prejudice. The FDLE only showed that there was blood on the knife, and it's not even material. If the court wanted to suppress the part of evidence, the state would be fine. I just don't see the prejudice.
Well, I think the issue is he's saying you all didn't give it to us so I could use it. Just because the state doesn't want to use it doesn't mean that it's not supposed to be turned over.
Absolutely. No, Your Honor, I do understand. I'm saying, what's the prejudice to him that he's alleging that for this delay in showing the FDLE?
Tell me what's important about this report, since I haven't seen it, Mr. Rolandi, from the defense point of view. I'm not trying to tell you to divulge some strategy or something, but I don't know what's in the report, so tell me what it is.
Without getting into facts of the case, and we'll wait for that, but so I have the report right here. It is June 3rd. I can show you the report.
Of what year?
2024.
Okay.
So the state maintained a position that a house knife was used, which was never stated. So this was very pertinent to early findings. It could have changed Mr. Swiatek's mind, which I want to apologize. I'll get a chance to apologize to him another time. But it could have changed the way that things trajected and how we went about the defense. So we just,
Sorry.
God bless you.
Thank you.
We just thought that it was very pertinent, and to get it that late was just, we wanted the court to basically assess that if that was, prejudice resulting, whether done on purpose or by accident, we could have used that and maybe postured much differently.
Okay. Well, let me state this. So, Richardson hearings kind of come in two somewhat different varieties. Often Richardson hearings are conducted in the middle of a trial where evidence comes out that you weren't expecting at all. So obviously that's huge prejudice, right? If you didn't turn over anything, or you didn't turn over something, and now you're trying to use it at trial, seems to be a pretty clear violation. But if it's been turned over and you've had it for a couple of months now, tell me what would have you done differently had you had it back in June? Other than time has passed by.
That would also be a question for Mr. Swiatek.
Okay, well, he's not here.
He's not
He
here.
was here earlier. I'm not sure if you saw him. But.
He said that he was going to put it for the dismissal early on in the very beginning phases.
Okay.
And we didn't do that, but if he had the Detective Wilson body cam footage, if he had.
Let's stick with the FDLE report right now.
Okay, because it was all dumped at the same time.
And so you see how I'm trying to do this one piece at a time, because they all have to be looked at a little bit differently.
Yes, Your Honor.
So even if they handed them to you all in the same time, what was prejudice about this one? What was prejudice about that one? That's what I'm trying to gather. But go ahead and answer that question. As far as what would have been done differently had you had that FDLE report in June of 24?
That would be the state and Mr. Swiatek. I can't do anything. I just think that it should be shared when it's given, if we're being transparent and we're participating in, fair discovery 3.22.
I agree with that part, but ultimately, so there's, in a Richardson hearing, you probably know this because you've done some research, right? There's three different elements or factors I have to look at. What was the failure to disclose something? Was it intentional or accidental? Was it trivial or substantial? And if those things are there, how did it prejudice your preparation for trial or in defending your case? And so I'm kind of on stage 3 just to find out if you can tell me there's something there before I really have to go through the analysis that kind of gets us to that point.
If you're asking my opinion, yes, I think it's dubious.
Well, but specifically how?
It's just, I don't really see a justifiable answer for it, but that's just my opinion. That's my legal opinion. Yours can be different, Mr. Swiatek, Ms. Leone. That's just, in my eyes.
Let me rephrase it, Mr. Orlandi, because I just want to make sure you understand my analysis. Assuming I agree with you, and I say they should have given it over at an earlier date, I think it's really important they should have. But what I'm asking you now for, what would you have done differently had it been given?
I would have put forth in the dismissal like I asked my attorney to do. So that's what I most certainly.
Can you still do that now?
We have, yeah.
Okay. And that's what I'm talking about. What didn't happen and no longer can in order for you to pursue your case because they didn't turn it over right away? And because then I'm going to ask them, because I think what I'm going to hear from them, well, I won't say that because you might think I'm trying to tell them what the answer is. And I would too if I were in your situation. But I'll get to that. But I just want to know, what are you claiming would be done differently? Had it been turned over, other than you would have filed a motion to dismiss earlier?
Other than that, I'm not claiming anything.
Okay. So, Ms. Leone, when did y'all receive this report?
I have access to the email correspondence with the Fort Walton Beach. We received it on December 4th, 2025.
So why would FDLE not send a report back? So was it sent to, when you say Fort Walton Beach, you're talking about the police department?
The police department,
Okay.
yes. I believe they had to subcontract the DNA report to Lab International, and that's in another state. I think it's in Virginia. And there was some kind of issue in that communication, I think.
So did it not go to FDLE?
FDLE sent it out
Okay.
to Lab International because they received a grant and they were able to submit additional, get some help with DNA analysis. Yeah.
So I've heard of FDLE doing things like that before, but it's usually when it's to do some sort of process they can't do in their own labs. But I've never heard of it on something that seems as relatively simple as this.
No, I've had it in another case, Your Honor. In a couple other cases, I guess they don't have enough resources over here, and then they have to ship it out. And this is what happened in this case.
Okay. So what does the FDLE report tell us?
What it tells us is,
You said blood on a knife.
so it's a scalpel. It's a medical scalpel, and it's a big difference from a house knife. So we thought that was very pertinent just to the narrative and.
So it sounds like what you're saying is it confirms your claim that this was done with medical equipment as opposed to an average steak knife or something like that.
Correct, Your Honor.
Okay, gotcha.
It shows that the blood, Your Honor, on the scalpel belonged to the baby. That's what it says.
What else would you like to talk about, Mr. Orlandi?
Okay, so moving on, the next part of the Richardson motion was the search warrant affidavit. This was also in the 12-5 dump, was shared on December 5th, 2025, and the search warrant affidavit was labeled under case 24 CF 154. That's just for the next motion, so that's the only reason I said it.
Sure.
So it was labeled under case 154, where Edith Rolandi was labeled as a co-defendant in the participation of an unlawful circumcision, in quotations. And Your Honor, we just bring forth to the state and to the court that there is not a statute in the state of Florida that bans or prohibits the religious circumcision of a child in a religious setting. So that
I'm not aware if there's a statute that covers either of those things, to be honest with you.
I did quite a bit of homework. I was unable to find any statute that says that circumcision of a male child in a religious setting is illegal. So that we thought that was kind of just strange how this was another piece of evidence that was just hidden until 12-5 as well. But it also made mention of some things that will go in with the other motions after this, Richardson.
I understand. So what is your concern with the search warrant? It's because you disagree that something could be unlawful?
We disagree with the language that we performed an unlawful circumcision because according to the law, the Florida state statute and federal constitution, there is no law.
Where is this discussed in the Constitution?
I believe that's the First Amendment, freedom of exercise of religion, the right to practice freely.
But what you're, yes, except there are cases where the Supreme Court has found that certain religious exercises could still be warrant of criminal prosecution. And I want to go down that road right now because that's not why we're here. But I understand your point, but all it is a search warrant saying they think you did something illegal, so we'd like to search X, Y, or Z. I'm not even sure what was searched. Again, I don't have the search warrant. So what was the search warrant for?
The search warrant was dated.
What was it? What were they searching?
They were searching my wife's phone.
Okay.
Because my wife was arrested the next day. So that's.
And was any evidence gathered from that phone, to your understanding?
The state has not. The state still has that cell phone, so I don't understand why we haven't been given it back after the 2-year time. But that property is still in their possession.
I don't think you're going to like this question, but have you asked for it back? Or has Ms. Rolandi asked for it back?
That was not in my, she has a counsel, Jason Cobb at the time.
Sure. Well,
so that's out of my ballpark.
Okay, But I don't know what was found on it. Ms. Leone, are you aware of anything that
Yeah,
was?
what was pertinent to the case was Miss Rolandi purchasing on Amazon through her phone the scalpel for the procedure. That the pertinence.
Was there anything else on the phone? I mean, have you given?
Of evidentiary value other than that, no.
Well, but have they been given a copy of whatever was found on the phone?
I can check, but yeah.
And again, as far as your side of the case, I know your wife's case is different. I'm the one that usually says that. Have you requested access to whatever was found on the phone? Sometimes, I don't know if they did. They looked through the phone, or did they use something like Cellbrite, which basically downloads an entire picture of everything that's on that phone, and they have access? I don't know.
Is it a possibility that we could just inform the state that we would like the phone back in court and maybe we can get our property back?
Not at this time, Your Honor, because it's part of the evidence in the case, and until the case is
How are you going to
resolved.
give them a copy of that evidence then?
I mean, the phone download, I'm not going to give him the phone itself.
Okay,
Yeah.
well, have you given them the phone download?
I'm verifying that, Your Honor.
Because I think there's something to be said about if the state or law enforcement takes possession of something and won't give it back, but also won't give you a copy of what was found on it.
Would you like me to proceed?
I'd like, she's looking something up, so I'd rather not jump around. So just give her a minute, Mr. Rolandi.
Well, while I look, I can ask, did you, Mr. Rolandi, did you receive the copy, or even your wife, did she receive a copy of what we got from her phone?
So I received a lot of things from the state as far as pictures, but it was never specified as from the defendant's wife's phone. So I do not believe that I received anything from what was on my wife's cell phone.
The photos seem to be accurate, what you're saying, because there were photos of the purchases, but I've seen it.
I understand, but was there, I don't want to use Cellbrite, that's one that's always used, like a Cellbrite image of the phone? Or did someone just flip through their phone and find what they wanted and screenshot it and keep those?
I'm checking on evidence.com, Your Honor, because that's how we share it. I'm having difficulties, Your Honor, accessing the case itself. I'm on evidence.com, but I can get to the case.
Sorry, say again.
I am on evidence.com, but it's not taking me to the case. So I'm trying different ways to locate it.
All right, why don't we move on to another issue and we'll come back to that one.
That,
Put a pin in that one. No, hold on.
Ms. Bosso was, we did share it on December 4th.
Number 4.
Yeah. In fourth amended discovery.
Looks like it might have been December 3rd, ma'am.
December 3rd. It was the fourth amended discovery, though. Yeah, it says Apple iPhone report.
That just says search warrant and return. I've got Fourth Amendment discovery filed on 12/3/25, and under additional reports, it says search warrant and return Edith Rowland phone.
That's the phone.
Okay, but is it just the search warrant and
It's the return, is what we got from it.
Okay. Does that include a copy of everything that's on the phone?
Yes. Yes.
Received that on that date and that download?
Your Honor, I'm looking at all my downloads, and I'm very good about titling it. We do not have that.
And so I'm wondering what was actually sent, if it was just the report about it, or was it the actual copy of everything that's on the phone?
What I see here shows that we shared the whole download. So,
Why don't we do this? Why don't you reshare it?
yeah,
Let 'em
I can
download
reshare it.
And I'm not saying we're going to ignore it at this point, Mr. Rolandi. What I want to know is just to make sure if you get it, you can go through it and then make any sort of determinations as to what's on there that you could have used previously.
Your Honor, if I may.
Go ahead.
I have dumps from the state. It's called Axon. Axon Scene Capture Photos.
Okay.
That's the title of the downloads that I have is Axon.
Okay.
I believe that's like the same as the body footage.
I think they do more than one thing, but that was my initial thought, but then I was trying to remember my old days as a lawyer, and I think Axon does something with cell phones too. Have you opened it?
All the pictures that we received were from like the crime scene, and I say
Okay.
crime scene, but those are all the pictures that we have.
So this is what I would say we do. I want the state to reshare, that link for you to download that's supposed to that's supposed to include the phone download. And see that goes through, and then I'll have you go through it, and if you want to file a motion based on what you found there, you certainly can. But again, part of the analysis for Richardson, again, is prejudice. So if you go through the entirety of the phone and don't find anything that would have helped you, then maybe there's not prejudice. But I'm not making that determination right now. I just want to make sure that you've seen everything. Because again, this is not the emergency Richardson hearing where there's a jury in the next room waiting on the case. It's pre-trial. So I'd rather have you get a chance to look at everything and then make a determination if there's something that you should have had before. Because that will lead to, is there a Richardson issue? Is there a Brady issue? Whatever. What other things do you want to talk about, Mr. Rolandi?
So just, I want to just continue with the Richardson, and this is why I didn't bring the 5 motions the last time, because this one's taken a little longer than
I know.
hoped.
And I appreciate you breaking it up for that purpose.
Yes, sir. So in continuation with that, though, it was characterized as an unlawful and harmful circumcision, but later it was characterized as sustained an injury to genitalia. So after that point, it was like circumcision was kind of like removed. And then all that was saying was injury to the genitalia, and the language of circumcision was removed. And then it was recently shared, and it's kind of like, that's what the Richardson was about, was like they kind of changed their prosecutorial narrative, like, okay, it was an injury.
Well, Richardson is about providing you discovery, not about what the state or law enforcement terminology is being used to describe something. So they can call it whatever they feel like calling it. It's what they provided to you. I'm not sure what I'm not sure what you're even arguing here.
We're just arguing the timing of the information, because it seems pretty simple. Like when you shared all the information, why not just share that information? Why withhold? You know what it
What
reminds me of?
information?
All this information was shared 12/5 of 2025, but the other information in body cams was, I believe, 3/19/2024.
Okay.
So we were confused as to why evidences that appeared to be favorable to the defense were withheld during that time, and why.
And that's why I'm trying to go through those things specifically, one by one. So we've talked about the body camera, although we didn't really get too far with that, I don't think. And then the FDLE report, and now the phone issue. So are we talking about anything other than those?
And then I believe the last part of the, let me just see here. So I had to go back and watch it, but I went back and I watched the 11/17 hearing with Judge Stone. And Judge Stone and I were both, wanting to know if the state was done with their evidence and sharing for witnesses. And Ms. Berickman said, yes, Your Honor, we're using the February 1st, 2024 witness list. And that was November 17th. Then, December 5th, only 7 days before we're to schedule the bench trial, Ms. Berickman added 4 brand new witnesses. And so that's when we filed the motion Richardson, because I have continuations by Mr. Swiatek for well over 18 months doing depositions. And you can go and look at all his continuances that he put, and they were all for depots. So when we were going to schedule the trial, the bench trial on 12/11, that's when Ms. Berickman on 12/5 put those 4 brand new witnesses.
Can I confirm something with you or not?
Your Honor?
When you say on 12/11 you were going to have the bench trial, that's the day you were going to set that later, right?
Yes, Your Honor.
Okay, that was the scheduling hearing, was to schedule that bench trial later. Okay.
It was supposed to be scheduled in the very near imminent future is what Judge Stone said he wanted to do. And then obviously, that he recused himself of that same motion.
Where?
So it was a little bit of a juggle. But we kind of thought that was prejudicing as far as in the time that they were sharing those witnesses, given it was so close to the setting of the bench trial.
Okay, and I don't know if this state has gone back and watched the November 17th hearing, because they probably don't have a copy of it. So do you have any response to that, Ms. Leone, about what he claims Ms. Berickman had said during a hearing in November? She wouldn't have access to see any of this stuff.
No, but the point, I guess, is that in reviewing the file and records here, probably the witnesses that were shared are likely the FDLE or DNA analysts that we got on December 4th, and that's when we shared. The other issue is we have an obligation to, when the state becomes aware of an additional witness or additional piece of evidence, to share it with the defense. And that's what we've done. The point is, whether or not Ms. Berickman announced a list of witnesses that she was going to call for trial, obviously I can state that since that happened on November 17th and she received the DNA results in December, that could have caused the change.
So who are the witnesses that were added in December, Mr. Rolandi, to your knowledge?
There are 4 completely new names. They're not on
What are the names?
I'd have to look for that, Your Honor, but I think there are like 4 urologists from somebody's urology department. I'd have to look, I can look right now.
Well, I would need that.
I can give that to the court. One is,
So is this the December 3rd, 4th amended discovery?
the date that I have here in my system, yes, it is.
I'm just reading.
Yeah, no, yeah, no, no, I'm just saying, based on, I'm not on the court's website to see the date when it got to the portal,
Okay.
but it is the same
The
one.
4th amended. Who's new on that?
I have it, Your Honor, if you want me to go, if Ms. Leone doesn't mind. I have the names.
Okay, go ahead.
So the first one is Jamie Belcher. That's a witness out of Fort Walton. It doesn't say their profession. Number 2 is Casey.
Hold on.
Oh, I'm sorry.
Who's Jamie Belcher? Possibly mute that.
I don't even know why I'm making a noise. I mean,
It's not me, I promise this time.
It's okay.
Thank you.
Is it possible that Jamie Belcher is either works for urology or county health department? I'm just looking up the address that's provided.
It says Racetrack Road, right, Your Honor? I'm assuming, it
I think
must
that's
be a
very large
professional.
office building, so.
For a very, I see the amended discovery exhibit. I don't have that name listed in the list of my witnesses, though. It must be some technical issue, but we did share it, yeah.
And then Casey Campbell is with the sheriff's office, right?
Did the phone download, yes.
What other names were on there?
K.C. Campbell,
I just said
That's-
that's someone who works for the sheriff's office who typically does a lot with the phone downloads.
okay, number 3, Cynthia Reeves,
Gulf Coast Kids House in Pensacola. What is their actual involvement? A quick search, she's possibly a pediatrics nurse practitioner.
They are. Yes, ma'am. You're correct.
Okay. Anyone else that was on the list?
Carol C.C. Saccone,
They're
It says
doctors.
CPT next to her name, so I'm assuming that's someone involved in the child protection team.
It's, yeah, Dr. Second, and then the last one, I guess, is Dr. Mark Weary.
Who was previously provided by your office, or your attorney's
From
office.
them, yes,
Right, Mr. Rolandi?
yes.
That's the person we've talked about already.
so what we brought to your attention, Your Honors, we have his assessments and his medical records, but we don't have any other further things from him.
We have what the defense shared with us.
What they're just basically saying is, and it says previously listed as a defense witness.
Yes,
So they're just, sometimes what the parties will do is, I want to make sure I list everyone that you listed, so that way I can use them too. Doesn't mean they're going to, it just means they're putting it out there that they could. A lot of times you see reciprocal discovery from the defense come as all states' witnesses and exhibits, without specifically listing anything. What did these people do, to the best of your knowledge, Ms. Leone, and why weren't they provided previously? And I feel like I have to mention this. You took over his case in the past month or two,
yeah,
but for some reason, these people are listed as witnesses who were not listed as witnesses for the better part of 2 years.
I don't have an answer to that, I don't know. I don't know, I'm gonna,
This is what I would suggest, Mr. Orlandi, because those particular, I don't see where you brought those witnesses up in your motion. Not trying to be critical of that, obviously. I'm just saying they're not. So do you want to take a look into investigating who they might be, or take their deposition, or whatever you're gonna do, and then make a decision if you wanna pursue any sort of Richardson issue there?
We would like the state to notify the defense when they're gonna interview these people, and we would like to be present and
Well, that's not how it works, so they can interview people and do their investigation without you involved. That's just for the same reason you could potentially talk to certain witnesses without them being involved. But if you want to have a deposition of somebody, people have to be noticed.
So when we had depositions done before, you could see that they were both in the room together, like Mr. Cobb, Mr. Swiatek.
That's a deposition, but the state doesn't have to invite you to every interview with a witness they have. But if they want to put it on the record as a deposition, they have to.
That's what we were implying, Your Honor.
Okay, well, but if they're not going to depose, you can depose them if you'd like.
I don't really, if the state is going to do depositions, we'd like to be present, but if they're not, then it's not.
Typically, a party deposes the other side's witnesses. But they're not going to depose their own witnesses. If you'd like to depose them, you can.
It's not necessary, Your Honor.
Because really the focus of your Richardson motion was the things we've talked about now, the report, right? The missing interview from the jail, which I think we've addressed, that there doesn't seem to be any sort of recording of that. And then the Detective Wilson's body-worn camera footage. That Detective Wilson, is that from Fort Walton Beach?
Yes, for Walton
Do you
Beach.
know why y'all didn't receive that until later in the game?
No, I don't
Sorry,
know.
I say that a lot, and I always catch myself.
No,
I don't
but
mean to call this a game. It's not. It's.
Understood.
Yeah, no, Your Honor, I don't know, but I can find out. I'll find out why he didn't share it with us to begin with. I don't know.
Or I'm on duty, so I got to carry the phone once we get to after hours. Have you seen this video, Mr. Orlando? The Deputy Wilson's body camera?
I have, Your Honor.
Is there anything you want to tell me as to what's on it and why it's prejudiced that you didn't get it?
So
You're prejudiced as to why you didn't get it?
I've submitted like timestamps and like exactly what he said. I can paraphrase like what he pretty much said, but he said, wait until the state gets a load of this. It wasn't like we thought it was. It was religious in nature. They performed the circumcision. The mother was reciting Bible verses. She was very forthcoming. She let us see whatever we wanted to see. He basically said they're going to have a very hard time prosecuting this, given to the fact that it's a religious ritual in the Bible. So that's the general gist of what he says.
Okay.
And then he was removed from the case.
Do you know that he was removed from the case?
I don't know about that. I don't know what he means by was removed from the case. Once the case is
Well,
closed with an
I just-
arrest, it's, you know.
I want to make sure you understand too, Mr. Rolandi. I think you heard me say this in another case, if you were here earlier, that a witness's opinion on the facts is not admissible. So an officer saying they're going to have a tough time proving this doesn't, you can't bring that in and show it to the jury or to me as the fact finder if you go forward with having a bench trial. It's just someone else's opinion. I have to make the determination, or the jury has to make the determination in a jury trial as to what the facts are and did the state prove it or not. So what I guess prejudice do you have that wasn't provided earlier? If it's ultimately inadmissible evidence, which is from what you're telling me, I think it is.
I think it is too, and I think that they tried to basically change the narrative, and that was just so, it was always just labeled as child abuse, aggravated assault, bodily harm. And we just heard that recycled and recycled repeatedly, but it was never like religious ritual, sincerely held belief. So those things, it goes to intent, it goes to motive. Every case is a case-by-case basis.
But the state doesn't have a motive. I mean, that's not what your motive, is that what you're saying?
Yes, Your Honor.
Okay. I'm sorry, that one flew by me for a second. I understand.
It's a pro se thing.
Yeah, no. Well, you're not wrong, because there's kind of this, like I talked about doctors being hybrids. When you're representing yourself, you kind of have a hybrid situation where you're making arguments, but also providing facts at times. So now I understand what you're saying. It's whether or not you had the intent or the motive to do something that's criminal in nature versus were you just trying to do something that was a religious ritual and maybe didn't go as well as y'all hoped. But again, I haven't seen all the evidence, but I have seen that there's some report about, I mean, I know you've talked about it in hearings, Mr. Orlandi, that there was some sort of revision, I think is the word that's used.
He called it a minor revision.
A minor
That's Dr.
revision,
Weary.
which I won't comment on, but a minor revision and there was no permanent injury.
No, Your Honor. If you'd like, we could, but I think you probably want to hold off on that discussion.
Yeah, I just remember that being what it was. So I understand what you're claiming now as far as your intent and or motive or lack thereof when it comes down to committing some sort of criminal act.
I'm sorry, Your Honor.
But I don't think, from what I've heard, you not possessing that video until later on, I'm not sure how it prejudiced you, as you even somewhat admitted, it's probably not admissible evidence anyway.
I just brought it to your attention to see, because it reminds me of the Duke lacrosse case. That's the closest case that I...
Let's not go there.
That's a big one.
I understand that. Let's focus on, if you want to cite a case, it's for actual law in this state or by some court that's above this one. But I'm not going to entertain arguments about other cases that are high profile in nature just for their sake of them turning out to be problems from the state's point of view. I understand what you're saying, but I want to focus on the issues that we're here for. All right. So as far as that, I don't see any prejudicial issue with that, or that it was substantial in the fact that it's been provided. It's been provided before your case was set for trial. And I'm talking about the video now of the detective. And then there wasn't any prejudice because from what you've told me it wouldn't be something you could use anyway. As far as obviously the DCF didn't record anything, so they didn't fail to turn anything over there. So my only real thing is the FDLE report and why it took so long, and what you would have done differently. And I think you kind of wanted to maybe circle back on that at some point, because I'm not sure what you would have done differently had you received that report earlier, other than you would have filed a motion to dismiss earlier.
That's exactly what we would have done.
Has a motion to dismiss been filed based on that issue since it was turned over?
After they downgraded the charges 2 days before that motion hearing.
Okay.
A very sister-related case.
Mm-hmm. I understand.
That's in the other motions. But he didn't address it again. So
who's he?
The prior counsel for mine and then prior counsel for my better half.
So was there still a pending motion to dismiss?
Your Honor,
outstanding motion to dismiss?
Everything that you have on today's notice of hearing is what we have left for you. And then really, at that point, the defense believes that we've kind of exhausted that scale, and we don't want to basically just kind of tread in the mud any further.
Oh, that's not going to happen. I mean, I think I've been pretty clear from the get-go that this is an old case and it's going to be resolved as quickly as it can, which is why you're here on your at least third or fourth significant hearing in the past 2 months. But I didn't see a motion to dismiss as outstanding, and it's not listed for the notice today, right?
It's confidential evidence until the bench trial. It was motion in limine, and it was fraud on the court.
Yeah, okay.
So there is underlying requests that we're asking for relief up until dismissal. but we were hoping that you would strike the witnesses or maybe just not even use them because they're so late in the ballgame. So we were.
Well, again, as far as those witnesses that you're talking about, the 4 witnesses who weren't listed on previous ones that were provided in December, you didn't put them in your Richardson hearing motion.
They were, it was topic, let me see, 69. So if you go to 169, the next down listed as one.
Oh, surprise ambush witnesses.
Okay, yes. So the fifth paragraph there.
You didn't list them.
We didn't list their names, but that was most certainly the witnesses that we were inferring to.
I understand, Mr. Orlando. One of the things, and I hold both sides' feet to the fire on these issues, you can't kind of vaguely say, and surprise witnesses and not tell us who if you already know about them. It's one thing to say, we don't want them to bring any other surprise witnesses, but if you know exactly who you're talking about, you should put it in the motion so that the state can say, let me look at these 4 before today's hearing and find out what they know, and do we even plan on using them?
So noted, Your Honor.
Okay. So what I would say, as far as the 4 that were talked about, I think I told you, one seems to be maybe with there's Belcher, there's Casey Campbell, there's Sakan, which is the doctor, and then there's Reeves. So what I would suggest is the state takes a look to see if they plan on using these people at all. I just don't want to go through all this analysis to find out they don't plan on using these people anyway. But again, you're free to investigate and find out what they have to say, Mr. Rolandi, because they may provide information that's helpful to you. I don't know. But typically that's done through a deposition, which you would have to set. Again, parties don't typically depose their own witnesses. All right, so let's go on to your next motion.
Just trying to look at how I had them ordered again.
I don't want to pressure you, Mr. Orlandi, but we're kind of short on time, so.
Very much so. I'm tired. I had to work really hard to be able to get here on time. So I just wanted to make sure that I had.
Mr. Orlandi, which motion would you like to hear next?
We'll do the fraud on the court.
And what number is that?
It's going to be 144. Kind of touched upon it a little bit. So
Is that called motion to dismiss for
Motion
fraud
to
on the court?
dismiss for fraud on the
Okay,
court.
okay, I got it.
144, filed November 18th.
Yeah.
So, Your Honor, we kind of touched upon it a little bit today, and that was what I was saving for you. So I went back and I looked at some of the documents from the beginning of the case. And it was interesting to me because I was focusing on it all last night and I was focusing on it all day today. So at the first appearance, it's written it with a scrivener's note for 24 CF 137. That's the first appearance. Now, the defendant's wife was arrested that night, that evening, 119, on case 24 CF 154, and listed as a co-defendant. So we bring it to the court's attention that when the defendant stood before the judge at first appearance on 119, we believe that it was 24 CF 154. And that's why when Judge Stone looked at,
What was 154? That's
The-
her case number?
so, okay, that's our case number. So we were originally one case, and it was 24 CF.
People are never one case. Two different people are never one case.
Okay, but so,
What you're citing is your first appearance paperwork that has the case number that you've had this entire time, right?
yes, Your Honor.
Go ahead. I'm not sure what, you keep, I understand religiously how y'all have talked about yourselves being the same. But when the government deals with people, everyone gets their own separate case number. So yours is 137. Hers is 162. So where do you see the 154?
So initially, on my paperwork, it's 154, and initially on her paperwork,
What
it's 154.
paperwork?
The charging sheets, in the beginning, the first appearance, the arrest paperwork, Fort Walton Police.
I'm looking at your first appearance paperwork says 24 CF 137.
The scrivener's note in the middle on the top?
Not Scrivener, but yes, it's handwritten because case numbers aren't generated before first appearance. They're being written on after the clerk processes it and then puts a case number to it.
Now, when Judge Stone first looked at this, he thought that the defendant had two cases. And the reason why is because he saw 137 and 154. And I think there's confusion as to if you're the 154th filing of the year, there's no way that you could go backwards and be the 137th filing of the year. So you can always move forward. You
I
can go to
don't
like.
see where you're saying it has 154 anywhere.
May I, Your Honor, because the only thing I can say that 154 refers to the agency number. It's 24-000-154. That's the Fort Walton Beach PD arrest number, That's what it is. I can,
I'm looking at it right now.
okay.
All right. So on all your paperwork, as far as a case number, our case numbers have a CF in them, criminal felony. So your court case number has always been 2024 CF 137. What you're talking about is a case number from the Fort Walton Beach Police Department. They have their own numbering system. You are 24-000154. Those are completely different numbers and unrelated. You might be the 154th person that they dealt with in 2024. But as far as criminal felonies, you're the 137th person that we've dealt with. Understand?
I do now. It's being a lot, there's what I'm researching from what I'm being told by the court is different. So I just want to acknowledge that's.
Well, that's what I'm saying. I've never seen that number anywhere. Now the state's told me 154 is that number. Now I'm looking at your arrest report, and that's where the 154 comes from. Those are unrelated.
Well, previously you had asked the defense, how does this prejudice you? Well, this is the defense's theory. When the defendant's arrested 118 and the defendant's wife is arrested the next day, the man that she's arrested to was not the man that she's married to.
I understand that part. They got your name wrong.
Not just the name.
They got your name wrong. They got your birth date wrong. I understand that. Those things have been fixed.
And
it's not a fraud on the court.
But we would like to just proffer for the record that when somebody's being detained and they're going to be released or detained at their first appearance, one of the determining criteria is if the person has a criminal record. And so this is why we're getting this evidence, because at the detention hearing, Judge Brown said, and I remember distinctly, Mr. Rolandi, I'm the one that gave your wife the signature bond. Had I have seen you, I would have given you the same thing. So I'm giving you the signature bond, Mr. Rolandi. So he was acknowledged, and he did see me for first appearance, but he didn't see me. He saw another man with a criminal record, and we want it proffered for the record that that is most certainly what happened.
First judge you saw at first appearance was Judge Ward.
But who signs the paperwork for that, Your Honor?
Judge Ward.
Judge Brown.
No, when there was a pretrial detention hearing set in front of Judge Brown, he then made that determination.
If you go on, Your Honor, onto the clerk site and you go to the first, all the way down, the first index, it's 8 documents, you're going to see, I'm fairly certain.
What number are you looking at?
It's going to be
I'm looking at the judge's record of first
11.
appearance. That's 11. First page says detention hearing on it, right?
And then it's signed, it's I think, what number is it?
There's no signature there on the first page.
Oh, but down the second or third
The
pages.
second page doesn't have any signatures, it's crossed out.
Yes, it is. The
Third page is Judge Ward's signature.
I'm sorry, Your Honor, I did think that was, because I saw his signature a couple other times.
I will tell you, if you took every judge in this county, and maybe a lot of them across the circuit, because I've been in 3 different counties of this circuit, I could probably tell you whose signatures are whose, because I see them all the time. Just like they could tell you mine just by looking at it, even though you probably can't make out a letter in my signature, because it's turned into a lot of squiggles over the years because I sign it so often. It's kind of like a doctor's signature, you can't read it, right? That's what ours kind of turned into over time. But I can tell you every judge in this county what their signature is just by looking at it.
Well, Your Honor, just, in the fraud on the court, in the body cam footage, when the defendant is being processed, the camera is shut off before the changing of arms and the identification of the defendant. And so the Duke lacrosse case is like there's.
I don't want to hear about Duke lacrosse cases anymore, sir.
Your Honor, can I make my argument, though? I have to
Make
put it
your
on the record.
argument, and then I'll make a
You're a
ruling.
defense attorney. You know, if I don't make it, nobody's going to make it for me.
Okay, go ahead. Preserve whatever you want for
So
the
the state
record.
had evidence that they knew exonerated the person, and they knew was an impeachable offense. And an impeachable offense is that he shuts his camera off because the other officer said, hey, turn your camera off. And they did not identify the defendant, and they didn't finish the changing of arms and turn the patient in. While the defendant was in the cruiser, he shuts his video off. And then we were tipped off by the state internal affairs investigation into this same individual that was known for falsifying affidavits. This is what the defense is bringing to you. It's a red flag. That the misidentification was not just a Scribner or a Scribner's error. It's tremendous. It's a violation of the First Amendment, the 14th Amendment, due process. Every person has the right to be, whatever nationality you are as an American citizen, you have the right to due process and to be done correctly. And that's what we're just trying to bring there. So that we'll leave that right there.
Anything else on your motion to dismiss for fraud on the court?
No, sir.
Motion is denied. Your argument up to this point is always focused on your name being misspelled and your date of birth being wrong, and your confusion that was done by no one else, your confusion about court case numbers versus police numbers, and thinking that one judge told you something when they had seen you before and you were wrong on that. Your motion is denied.
Your Honor,
Next motion.
And we would just proffer for the record, anybody in my situation would want their rights. It doesn't matter who you are or what you are. Just
I
because I want
understand.
my rights doesn't mean I think I'm guilty.
This motion has nothing to do with your rights to exercise your religion. You're trying to say that the state has committed fraud on this court in some way. You've
It's a
told me
strong
what your
argument.
argument is. I've denied it. Next motion, please.
We would like to proffer for the record that we take exception with your ruling.
That's fine.
Moving on, the motion in limine was connected to this. It's very short. You're going to say no to it, I'm sure. But it's in regards to
What
any.
number? $145, does that sound right?
I think so, Your Honor.
Okay, go ahead.
That was very cut and dry. We're just asking that, our relief that we requested is that, when you looked on the fraud on the court at the bottom, the right name was there. So on the original form, it is Rolandi. Then it's scratched out, Roland is above it, and then it's AKA Rolandi below it, which we just view as dubious. Because pick one. Who is it? Is it James Roland or is it James Rolandi? So any evidence that had that dubious error that should have been corrected from the pinpoint beginning, we would ask that you would look at sanctioning that evidence.
Motion's denied. They're not going to use anything that has your wrong name on it as far as that isn't you, Mr. Rolandi.
Your Honor, if you go on the top of the clerk's site, it's still the wrong man in here. Just because you made it right on one.
No, because once it gets put in as one thing and it gets fixed, it still shows as an AKA, so that there's not a confusion as to which one, which case it is. And frankly, the clerk's website is not evidence it's going to be used in your trial. What else would you like the court to hear?
Lastly, for today, we have the confidentiality of the evidence that's submitted.
What evidence?
Any evidence that's related to that, we would like it to be confidential until the bench trial. That's really for your eyes.
There shouldn't have been any evidence filed in the case. Like I said, evidence is things that are brought to the trial or a hearing and introduced as evidence. I think what you're misconstruing is you filed things.
I did, Your Honor. I made a mistake.
I would say inappropriately.
Yes, I did, Your Honor. So I was asking for
what specific things are you asking to be found to be confidential?
Really, we just wanted that evidence because that's kind of like our strategy and all types of things.
Well, then I don't know why you're filing them in the court file.
Your Honor, this is not an easy job.
I've done it, so yeah, I know.
So you know well, so this is, and I told you, I called people, I wanted to have them come, but it's just, right now, I don't want the state, and I don't want a court-appointed attorney, but we were seeking, so I'm just doing the best I can. But Judge Stone had told me, I need that evidence, you gotta get it to me. And so I followed the order and the command.
In a proceeding, so.
I think it could be easy to take advantage of someone like me, so either way.
Who's taking advantage of you?
I'm not an attorney. I mean, people are trying to fool you all the time, and this is how this game works.
I'll make sure that I put this, despite the fact that I'm not supposed to give you leniency and some sort of, hold you to some extra, I think I've given you more than ample opportunity to argue the things that you want to argue, and I haven't held you to quite the standard that I would a lawyer. So I'm not sure who's taking advantage of you. I don't allow for these kind of blanket accusations to be thrown out, because if you're accusing the court of taking advantage of you in some way, I'd like to know specifically what you're saying.
It's not in reference to you.
Okay, well, then whom are you referring to?
I'm basically saying that Judge Stone asked me for the evidence and I submitted it on the clerk's site instead of doing a notice of filing, and I could have sent it to your JA and I could have sent it to the state. So I know that now, 2020 is hindsight. But again, I mean, if someone looks at the evidence.
How is that taking advantage of you?
No, if someone looks at the evidence, it's all good with me. I'm not concerned.
All right, so are you withdrawing your motion?
That one there, I guess we can call it a day.
I would suggest you don't file any evidence in the court file unless you're either specifically told or it's been admitted at a hearing or a trial.
I was told that if we're going to bench trial, Mr. Rolandi, we need your arguments, we need your witness.
At the
or
trial.
We need what you're gonna present, and so I presented the evidence that I plan to use for you during a bench trial.
Anything else that we need to address?
I believe we touched them all, Your Honor.
Okay, so are y'all ready to set your bench trial at this point?
But we said it, Your Honor.
Did we?
Yeah, for May, we even chose the dates. I forget now what they are.
You're probably right.
May 20 and 21.
Yes, yeah, sounds right. Okay.
Let me put that in my Outlook calendar just so I remember that going forward. And that's just, that's just your trial, Mr. Rolandi. That's not your wife's trial.
Is there
She
a chance
hasn't-
that could change now, though?
She hasn't asked me to set that for trial.
I think we
And-
both
and
have
I-
the same attorney now.
Who's the attorney?
Yahweh. Yeshua. Jesus the Messiah.
Typically, co-defendants are not necessarily tried together. And again, she hasn't asked for her case to be set for trial that day.
Is there a possibility that that could change, though, if we?
Well, I haven't even gone over, number one, her FREDA inquiry, which we're not going to have time for today, because it's 4:46, and actually, it's 4:53, and I still have another case to handle. And then, I don't know if she's ever been questioned about whether or not she wants to waive her right to a jury trial. I know you have done that, and it's been talked about, the state had done that at some point, and Ms. Leone, in fact, said, I'll stay with that because that's what the state had previously argued, but she wouldn't have done it if she was making the decision at the time. So I have to go through that with Ms. Rolandi as well, and so I'll do that at a future date because we're just out of time and that wasn't set for today.
Sure thing, Your Honor.
All right. All right, so we're going which is just questioning you about it. I want to make sure that everyone's on board as to what the evidence is, what's been provided. There's nothing else to talk about. And then that we're ready that we're going to be ready for those particular days. And there's not going to be any witness issues. Subpoenas have gone out. Everyone's ready to go. So I'll let you appear by Zoom for that if you want, Mr. Rolandi. I've given you that opportunity before, and we can put it in a time that it's not going to be as difficult for you. I think I've offered that before. You were concerned about having to drive up here once the case got assigned to me because y'all don't live in Prestview, you live in the South End, is what you said.
Is there a chance that I could do a continuance with you and I could just show up for the trial? You could waive my pretrial conference
So
that day?
well, it's not just for you. Both parties have the opportunity to do something.
Does the state want to throw me a bone? I would rather not come if I don't have to. I mean, I think it's just, we're gonna come and say what? Like, it's just gonna be like, okay, hello, all right, goodbye. You know,
All right,
and
so you're saying you're done filing any motions?
the defense rests its case with that. I don't want to tread in the mud any longer.
That's fine for this.
Then we'll be set for trial the morning of Wednesday, May 20th. I want you to be here at 8:30 in the morning, and we'll proceed to trial. Let me just make sure you understand a few other things then. Raise your right hand, Mr. Rolandi.
Yes, sir.
Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, Yahweh, I do.
Now, I'll just ask you a few things. I don't try to belabor this thing, but you feel comfortable going forward with without a lawyer at this trial?
I told you, I'm working on it. I'm trying, but.
All right, then we're gonna have a pretrial conference. It's gonna be on April 27th at I'm gonna give you the opportunity to not have it where you have to wait all day. I'm gonna say at 3 o'clock. You can appear by Zoom if you'd like. But I'm not gonna hear about how you're gonna hire a lawyer between now and then, but you're not telling me for sure if you will. So we'll address all those things. That will be the last court date that we have before the trial.
That sounds good, Your Honor.
But I'm allowing you to appear on Zoom if you'd like to. Just confirm at my office if that's your plan.
And I'd have to file, right?
No, I'm saying just tell us,
Okay.
so I remember. But I'm fine with you appearing by Zoom. I just want to make sure I don't forget about you. And if no one tells me they're on Zoom, I often don't turn the Zoom on. So I want to make sure I know you're going to be there on Zoom or in person or whatever. But I'm trying to put you later in the day so that way you don't have to sit for a long time. And I'll try to take your case right away. But I don't want it to be a situation, if you've got a lawyer who's jumping on, he or she is going to have to be here on that day. What I don't want to do now, if I've special set 2 days for your trial, is have you hire a lawyer and then you want to continue it. Again, it doesn't bother me any when cases get set, but I don't want it to be a situation where it has to be continued and it's going to be hard for me to find 2 days like that again.
We don't want to do that to you, Your Honor.
Well, it's not about,
The
again, it's not
defense
to
won't
me.
stall this at all.
I don't want to be in a situation where I tell you, well, now that we have to continue, it's going to be 2 months or 4 months later because we didn't have one last pit stop before we got to the trial.
The defense doesn't want to stall the process at all.
Okay. Well, your trial's set, but so is your pretrial conference.
Thank you, sir.
All right, thank you. All right, Mr. Maddox, are you ready to do the rest?
Yeah, Sean.
This gentleman in the black shirt, his name is John Dennis, and he's under the impression that he is here for an early termination of his probation.
Sorry, who's that?
John Dennis.
That one's familiar to me.
I don't know that it'll be heard today, but he's been here, and I just figured. Delaware.
Judge, may I approach with that order for Mr. Baker?
Sure. Didn't I do it electronically?
I did. I did it both ways. I thought you meant.
Then
you were gonna
I
sign
won't
it.
need this.
Okay, no problem. I filed it. I believe we also sent a copy to the J, so just whichever you prefer, John. And then the jail has already been reached out to by the APD, which is good.
Mr. Dennis, who told you your hearing was today?
Your Honor, I received an email, I believe, from your assistant.
Okay.
Saying today at 2. It was threaded with another person. So after that, there wasn't like anything confirmed or denied, so I decided to show up just in case.
All right, let me handle this other hearing real quick, and then I'll see if I can handle it today if you guys want to try to look it up. So motion for early termination of probation, cases 2023 CF 2612. All right, let's go ahead with Mr. De La Rosa so we get that in.
De La Rosa. Appreciate that, Your Honor. No, sir. Your Honor, this is Mr. De La Rosa before the court in 24 CF 1700 per his Nelson hearing request.
Mr. De La Rosa, can you raise your right hand to be sworn? Do you swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
I do, sir.
Make sure you're speaking into the microphone.
I do, sir.
All right, thank you. All right, let's get back to it. All right, tell me why, let me just make sure I'm clear on what you're asking for. Are you asking for Mr. Maddox to be taken off your case or for you to get a new lawyer?
Yes, sir.
Okay. All right, tell me what you think Mr. Maddox has done ineffectively for you.
I put it on in the request that I sent in. I can't remember.
Would you like to tell me what that is now?
If I may then, Your Honor, just based on the written filing, I'm not sure there's anything in there that would be sufficient to raise anything that I've done that's ineffective. If he's gonna rely on his written motion, other than the accusation that I haven't done depots, which I have, and haven't sought an evaluation, which was previously sought by counsel. So I don't know that the court even needs to address any further, but if it wishes to, certainly it may, of course.
Tell me what you think he's done ineffectively, sir.
Well, I've asked multiple times for my paperwork.
What paperwork have you asked for?
I'm trying to remember the words.
I'll just stop him. To the extent he's asked for any discovery, our office will provide it. If it has been requested and not provided, it's an oversight on our part, and we will make sure he gets it. But I've gone over all discovery with him and gone over the depositions I've done with him, gone over all the psychological reports I have, the competency evaluation, the insanity evaluation that we sought. So he's been made aware of all that. All the paper copies certainly we can provide.
Yes, I would like a paper copy of everything.
Maybe everything we have.
Okay,
Anything else?
I guess not.
All right, that's all set.
All right. Motion is denied.
Thank you, Your Honor.
Mr. Maddox, you asked to hold on to
did.
forward. Do you need him out here?
I don't want to make an issue of this, Your Honor. I just forgot to inquire it while I was here. Yes, bring him out.
Okay.
Just wanted to inquire as to what Mr. Ford's bond was. I think that he's being held with no bond on failure to appear, but I just want to make sure I'm not missing something. I'm not going to address his bond today, obviously.
Why are we bringing it back up?
I just wanted to be here for you to tell him what it was,
Okay.
because I got lost in the paperwork.
So you want me to look it up so I can tell you what it is?
That's it, yes.
I don't know, Mr. Rat. Have you tried looking it up?
I looked at, I was just slightly confused by Your Honor, because it appears there's some old failure to appear, and I can just address it later on, Your Honor.
I'm not trying to be difficult.
No,
but,
I know.
mean, there's
I should have asked about it. It's late. It's fine.
159 docket lines that I have to look for.
I'll follow motion if need be, Your Honor. It's all right. Tell Mr. Ford I'll look into his bond like I told him.
On the lease.